creative communication skills. She currently works as a senior associate patents in IPR division at Plentex Business Solution, where she specializes in IP strategy, drafting, industrial design protection, and IP awareness trainings. A gold medalist and GPTA ranker, she holds a master's degree in pharmacology from a prestigious Bombay College of Pharmacy. She stands out not only for her academic excellence, but also for her engaging approach to teaching complex IP concepts with clarity and relevance. She has conducted numerous sessions on type of IPR, patents, design protection, and IPR fundamentals for students, researchers, and faculties. Her ability to simplify legal technical information into meaningful content makes her valuable speaker in academic FDPs and training workshops. Beyond her technical domain, she is also a certified communication and personality development coach with a passion for leadership, reading, and innovation. She has honored with her school's Lifetime Achievement Award, reflecting her long-standing commitment to excellence and positive impact. Her expertise areas are IPR education and awareness, patents, copyrights, trademarks and design, industrial design strategy and filing, science communication and legal drafting, academic mentorship and presentation skills. We welcome you, ma'am. You can take over the stage.
Hello, everyone. Hello. I think the registration process can wait for a bit. May I have your attention, please? Earlier, I was introduced. Thank you so much, ma'am, for the introduction. Well, I would like to introduce myself in a very different way here, which doesn't go with the millennial audience, I guess. But let's just dive into that. So, well, I'm Janvi Shetty. I have this trademark line of mine, which is very popular these days in one of my videos, wherein I start introducing myself like this. Hello, everyone. I'm Janvi Shetty, and I'm your Gen Z patent agent. Gen Z वर्ड सुन के थोड़ी सी चिढ़ होती है आज कल के प्रोफेसर्स को, right? You guys don't like us much, but I'm pretty sure after this session, you all might develop a liking for us, for our creativity at least. Okay. How do I move to the next slide? Okay. It's not working. Sorry? All right. We all must have studied about it. This voice is clear, right, for everyone? I hope it's not bothering. Okay, cool. So, when I was in 9th grade, we were introduced with this topic of economics. And it was pretty new. Later on, it got scraped off. But then there was an intent behind that subject. We were taught the basics of economics. And wherein I came across this term, tangible assets and intangible assets. Have we heard about it before? Anybody from the crowd? Okay, yeah. So I had one hand denoting that she had heard about the term. So let me tell you about it. A tangible asset is something which can be touched. And an intangible asset is something which cannot be touched. That's the basic definition of the two terms. Now, what comes under tangible assets? You guys are using your cell phones, right? That's a tangible asset. You can touch it. You're sitting on a chair. That's a tangible asset. Correct? Some of us are wearing specs, again a tangible asset. What if, I'll give you one scenario, there is a house break at your place. Somebody has stolen something from your place. Where do you go then? किसके पास जाते हो अगर घर में चोरी वगैरह हो जाती है तो? पुलिस के पास. Very nice. Okay. What are the other methods of safeguarding your tangible assets? कैमरा इंस्टॉल कर सकते हो डोर पे, करेक्ट. और क्या तरीका है? मेंटेन डिटेल एसेट रिकॉर्ड्स जो हमारे लैब्स में होता है. बच्चे थोड़ा बहुत ज़्यादा यूज़ कर लेते हैं रिएजेंट्स वगैरह तो टीचर्स डांट लगाते हैं. यू नीड टू कीप अ चेक ऑन ईच एंड एवरी क्वांटिटी ऑफ द रिएजेंट, राइट. फॉर दैट वी मेंटेन अ रिकॉर्ड. सिक्योर फिजिकल स्टोरेज, बैंक के लॉकर्स में जाकर हम हमारा सोना वगैरह रख सकते हैं. Other than that, there is insurance coverage, implement preventive maintenance. So all these are well said and done to protect our tangible assets. But what about those assets which come out of our brain? Brain से क्या आता है? ऐसा कुछ आइडिया जो आप सोचते हो, right? जिसको आपने एक इन्वेंशन में कन्वर्ट करी है. Am I right? So those all come under intangible assets. अब हमारे intangible assets को safeguard करने के लिए कौन है? Who is the one who safeguards our intangible assets? At least in India, we have Intellectual Property Office that is responsible for safeguarding our intangible assets. Now, what is all this about intangible assets or what is intellectual property rights exactly about is what we are going to see. Intellectual property rights are those rights which come out of our brain in very simple terms, for which you can obtain protection, you can safeguard those rights, and then you can use those rights for your benefit or for the society's benefit. That is all about intellectual property rights. Or in order to safeguard these rights, we have Intellectual Property Office. But what exactly is IPR? Achha, chalo, let me give you a very basic example. I see a lot of females here. All of us are fond of doing makeup, right? Crowd काफी ठंडा है. All of us are fond of doing makeup, right? All the females. Even I am. I am a fashion enthusiast. I love fashion. I love makeup. So I have a very beautiful lipstick in my hand. And this one lipstick will clear everything about intellectual property rights. So this one lipstick is of the brand Shiseido. Chambord का एक branch है which manufactures these lipsticks. Now I'll tell you what is the very peculiar thing about this lipstick. Of course, as a female, when you go and purchase a lipstick, what do you look for? The shade, whether it goes well with your complexion. How is the formulation, whether it's long lasting. I can tell you I've used this lipstick, okay, ever since morning I've used it. It has lasted me for 6 hours. So this is a mini influencer thing going on here. You can surely purchase this. Alright. So this one lipstick has multiple IPRs. Let's dive into it. मैंने ये देखा, this is a very peculiar design. ऐसे टाइप का डिज़ाइन I have not seen anywhere in any of the lipsticks. Why is that so? Reason, it is easier to hold it. The grip is easy. It's nice to look at. It is very sleek, it is small and it easily fits into my pocket. That is what I am looking for a lipstick, right? Now I open the lipstick. अब मैं क्या कर रही हूँ? I'm trying to move it. I'm trying to rotate so that the lipstick comes up. यहाँ पे कुछ तो एक छोटा सा mechanics is involved, right? There is a small mechanism that is involved in this. Next comes the formula. The lipstick stays intact even in summers. It gives good application properties. It stays longer. Now I'll tell you how each and every IPR is integrated into just this one product. Okay, there are 3 main IPRs which we always talk about. One is patent, second is design, and third is copyright. There is another person who is very famous among our Indian vendors or Indian market for the branding strategy. That is trademark. So all these four are involved in this one product. When you look at the design of the product, it's very unique. Have you ever seen a lipstick which has grooves or design like that? It is very unique for this product. So here you secure your design protection. Again, when you just open the lipstick, there is a mechanism involved to push the product up. So this mechanism, which is totally based on mechanics, comes under patent protection. Now when you move on to the lipstick proper formula, it again goes into patent application. Then there is a nice branding done on this lipstick. Shishido likha hua hai. That's the brand of this lipstick. So that comes under trademark. So my point is, one product can have multiple IPRs. Now, in a way, मैं ये lipstick की branding कर रही हूँ, right? I'm advertising this lipstick in front of you guys, how it is so good than others and everything. So this entire script of whatever I'm speaking right now can be protected under copyright. That's the clear-cut distinction. That's it. इतना ही है पूरा IPR. The entire 37 slides that I'll walk you through is covered in just this one lipstick. So can we go through this again? I need an active participation from the crowd. Otherwise we won't learn anything today. Okay? So when I see the product, what sort of protection comes into my mind? May I have the answer? Just by seeing the product, I can witness design protection. Excellent, excellent. As soon as I remove the cap and use this mechanism can be protected under. Amazing, amazing. The crowd is very smart. Okay. So when I see this formula, how can I protect this formula? Patent protection again. I'll go into detail why as to patent is focused on so much when it comes to formulations as well. Okay, now I close the box. I close the cap. I have a brand name written on it. How can I protect this? Amazing. And the entire script of the advertisement? Done. All right. So, but what exactly is IPR? It's all about invention. It includes software, art, literature, shape, configuration. The one that I mentioned about the lipstick, the external appearance of the lipstick constitutes the shape, how nicely it is shaped. Just by looking at it, you feel like, yes, I can buy that. It is pretty easy to hold as well. Distinctive sign, as in it has a brand name of its own. Also, it has a shade written behind. That all constitutes for trademark. Next is creativity. But what exactly is IPR? I always define IPR in very simple terms. मुझे complicate करना बिल्कुल पसंद नहीं है चीज़ों को. कोई मुझे आके पूछता है as a patent agent कि how do you define IPR? I just simply say कि IPR is anything that comes out of your brain. It is all about creativity. How creative your brain can be, everything is protected under IPR. So, when it comes to IPR, these are legal rights, intellectual property rights. नाम में ही लिखा हुआ है. Intellectual is something that comes out of your brain. Property is when you make that idea into something, into a product or into a name, or you give it as a distinctive sign that becomes your property. And when you safeguard that property, that is known as intellectual property rights. That's the complete breakdown of the term. So these are legal rights that are either granted to the individual or even to the organization. For instance, कभी भी आप पेटेंट फाइल करने जाओगे ना, I'm sure most of you might move ahead with some of your applications or you have already filed. So I'll give you a little heads up. There are two columns that are mentioned, applicant and inventor. दो चीजें mention की जाती है. जहाँ पे ना, when it comes to inventors, only alive person, the people who are alive can only be the inventors. And when it comes to applicant can be as simple as an institution का नाम. जरूरी नहीं है कि इंसान जिंदा रहे, institution भी हो सकता है. Okay? So that's the beauty of patents. Patent can be granted to an institution as well as to the individual. So these are legal rights that are granted to individuals or organizations in order to protect their creativity. अब एक डायग्राम दिया हुआ है यहाँ पर, IPR, technology, art, creation, law and business. Let's understand what is this integration all about and why is IPR written at the center. जब भी किसी ने ये लिपस्टिक बनाने का सोचा होगा ना, it must be their intellect that has come into power, right? वो दिमाग यूज करके उन्होंने ये प्रॉपर्टी बनाई है, correct? Am I right? It takes a hell lot of efforts to come up with a creation. So that comes under technology, art and creation. Now you will ask कि art and creation तो ठीक है, acceptable, but why technology? How come technology is coming into the picture? When I mentioned there is a mechanism involved to move this particular applicator, that itself shows that there is a tech involved. And whenever there is a tech involved, patent follows always. I hope I'm clear until here. Okay. So once you have your intellectual property in place, you go to a patent agent or you go to a lawyer to file either patent, copyright, design, trademark. You are bound to have legal protection, which comes under law. So in case if someone else is trying to use your property, your intellectual property, you can sue them. You can always come to me, of course. As a patent agent, you guys are always welcome. And now how come business? पहले वाले session में, like pre-breakfast, we heard a lot about this tech commercialization, these fancy terms by our speakers, respected speakers, right? It is all about business. Once you have a product in hand, once you file your intellectual property rights, you get it, then you can commercialize it. Of course, we have future sessions wherein this commercialization part will be covered. But for now, you need to understand that IPR alone cannot function with inventions. There has to be an amalgamation of law, technology, art, creation, as well as business. That's how IPR works. Okay. There is this classic case of Netflix. Are we all aware? Initially ना, when Netflix was introduced, एक पर्सन के आईडी पे कितने भी लोग हम देख पाते थे, कितने चाहिए उतने देखते थे, right? But now there are multiple plans, if I'm not wrong. For 145 rupees, only 2 screens can be shared. तो वो cost बढ़ते जाता है. Why did they do this? Because Netflix was facing losses. दिख रहा था कि एक हेड पे multiple लोग देख रहे हैं, and they're just paying cost for one person. Plus the platform or the technology in itself is very expensive. आजकल मूवी डिस्ट्रीब्यूशन के राइट्स लेना are very very difficult. So ये सब प्रॉब्लम्स को मद्देनजर रखते हुए this Netflix people came up with a concept wherein only limited number of people will be allowed for limited screen. So when Netflix can be so cautious about their product, why are we not cautious about our own product or about our own intellectual baby? You know, this is why awareness is really important. I'll give you many examples in the following session wherein you'll actually see how intellectual property helps when you have your rights in place. It basically helps you to prevent yourself from getting used by others for no reasons. Now let's understand, ये Indian Patent Office में these two terms are very famous. अगर आप कभी hearing में या trademark की hearing में बैठोगे ना, तो ये दो terms are very very famous. IP rights are negative rights and IP rights are monopolistic rights. Now what are negative rights? अरे ये ऐसे क्यों बोल दिया? कुछ लोगों को ऐसा लगता है कि अगर उनके पास पेटेंट है, ट्रेडमार्क है, कॉपीराइट है, तो वो लोग उसको बेच सकते हैं. That is completely a myth, okay? Just because you have an intellectual property right in place doesn't mean, it does not give you a validation that you are the only person who can commercialize it. That doesn't work that way, okay? In case you're short of funds and everything, you have to approach people. Of course, the entire world is moving towards interdisciplinary sciences, so why not just be at one place when we can explore many other things when it comes to commercialization. Hence, IP rights are negative rights because they do not give you the right, sole and whole right that you are the only one who's going to commercialize it. नहीं, ऐसे नहीं होता. As soon as your patent term expires, everybody is free to use that. Okay, so that's why IP rights are, can I hear from the crowd? IP rights are negative rights. Now, IP rights are monopolistic rights. ये भी बोलते हैं. Monopolistic rights का मतलब ये होता है कि for that particular amount of time or for that particular duration, you have sole ownership over your intellectual property. Nobody else can claim it. Even if they claim it, you can sue them in the court. That's the beauty of IPR. Yeah. From the earlier slide, IPR do not give you the right to commercialize. Anybody can do so after the term duration ends. IPR can be sold, licensed and mortgaged. In case if you have an IPR, in case if you have protection for your intellectual property, you're always free to sell it or license it out in case you fall short of resources. One product can have multiple IPRs. As proven in the earlier example, एक ही product में हमने 4 चीजें देखी. Okay, so these are the types of IPR that we are going to see. Industrial design, copyright, geographical indication, trademark, trade secret and patent. All right. Here's an interesting story for all those who are dozing off. एक छोटा सा स्टोरी टाइम करेंगे, ओके? मैं एक बहुत अच्छी फैशन एंथुजियास्ट हूँ. मुझे फैशनेबल कपड़े पहनना, wearing nice jewelry, presenting myself, I love it. And one day what happens is, I get influenced by these Instagram creators, okay, content creators. और मैं क्या करती हूँ कि मैं अपने लिए एक बहुत अच्छा डिज़ाइनर ड्रेस बना लेती हूँ. ओके, आई मेक अ नाइस डिज़ाइनर ड्रेस. और फिर सिंस आई डोंट हैव रिसोर्सेज ऑफ कोर्स, आई गो टू अ फैशन स्कूल. I ask them, you guys must be aware, right? SNDT also participates in fashion events. So you all must be aware that this is possible. You can go and collaborate with them just to present your designs. So this idea strikes my mind. I don't have the resources. मेरे पास उतने पैसे नहीं हैं. तो मैं क्या करती हूँ? मैं अपना डिज़ाइन लेती हूँ. I go to some institution. I collaborate with them. I ask them if I can present my design in your fashion show. And they are like, you're always welcome. कोई भी बाहर से आता है तो you guys are always welcome. So I'm very happy. I put my energy, I put in all my savings. I prepare for the fashion show. Fashion show होता भी है. I pick up a nice model. She walks with my dress. And my dress is recognized by everyone. तालियां बजती है, फैशन शो के बाद मुझे बुलाया जाता है, पूछा जाता है कि अरे ये डिज़ाइन का आइडिया आपको आया कहाँ से, इतना सुंदर है ये. I'm like, it's just my brainchild, that's it. अब cut to the story. An year later, मैं जुहू के रास्ते से जा रही हूँ, ओके. मैं एक बुटीक एंड आई सी दैट मेरे ही ड्रेस के डिजाइन जैसा वहाँ पे सेम मैनिक्विन पे लगाया. द मैनिक्विन हैज दिस एग्जैक्ट सेम ड्रेस एंड आई एम इन वंडर कि अरे दिस इज माई पर्टिकुलर डिजाइन, व्हाई this here suddenly, all of this sudden, and I have no answers. Just then I walk into that store, I ask the manager or I call in the designer, I ask him, this is my design, why are you showcasing it here? What's the intent? As in, I did not ask you or I did not approach you guys to present this design, so how come it is here? And they are like, no, it's not your design, we have made it, it's our design, ये हमारा product है and we are selling it off. And I'm like, nahi, this is my product, why am I gonna live my rights, right? I go on and I tell them I'm gonna sue you guys in the court, let's see you. Of course, we'll fight in the court and I'll get my protection back. And then I go to my patent agent, of course we have sir here. I go and ask him, सर एक साल हो गया, एक साल पहले मैंने ये डिज़ाइन प्रेजेंट की थी एक फैशन शो में, एंड नाउ द थिंग इज़ दैट दे हैव ऑलरेडी presented the design, the store is already selling it, is there a way wherein I can sue them? सर बोलते हैं आप एक साल बाद आए हो, एक साल से पहले आते तो फिर भी मैं आपको हेल्प कर सकता था, but अब there is no way round. You have to give up on your idea. Sad life, right? कितना बुरा हुआ यार मेरे साथ, सारा आइडिया ही चुरा लिया लोगों ने, and I don't even get the credit. This is what happens with a lot of fashion students, I'm telling you. Their ideas are so unique because fresh mind, again Gen Zs are very creative, ऐसे ही हम लोग बदनाम हैं. Okay. So we are very creative, we come up with new stuff and everything, but then we don't get recognized. ऐसे ideas चुरा लिए जाते हैं. So when you are aware of your rights, you can fight for it. अगर आपको पता ही नहीं है कि you can have a design protection for that particular product, then that is of no use. So now what exactly is industrial design? There is this misconception, design patent करके बोला जाता है, which is a wrong term. Patent is different. In India, it's industrial design. So I hope it's clear. We are henceforth not going to use the term design patent. We are going to use the term industrial design. So what exactly is industrial design about? जैसे कि I showed you this one particular lipstick, right? कैसे दिखता है? काफ़ी अलग है, right? There are grooves here. So जो भी प्रोडक्ट का एक्सटर्नल अपीयरेंस होता है या फिर एक्सटर्नल शेप होता है, पैटर्न हो गया या ऑर्नामेंटेशन हो गया, you can get protection for that under industrial design. So it's basically this tagline that I have come up with. जो दिखता है वही बिकता है. So if you want to sell your product which has aesthetic appeal, of course you can go for industrial design. So industrial design protects the visual appearance of a product, they do not protect the functionality. Now you'll ask कि फिर इसमें क्या-क्या protect किया जा सकता है other than this just lipstick का design? Suppose you guys come up with a nice jewelry design, very dainty, very aesthetic, you can go for design protection. अच्छा, let me tell you a very interesting fact which even I got to know very recently. आप लोगों ने बेकरी में प्रोडक्ट्स देखे होंगे, बेकरी के प्रोडक्ट्स, राइट? Very famous, very trending. I don't want to spell it because I am very sure I'm going to miss out on the pronunciation. There is this croissant, am I right? Okay. So that particular shape is very famous, right? We are very inclined. कहीं पर भी देखते हैं, अरे ये तो ट्राई करना है. Starbucks का सबसे फेमस प्रोडक्ट कौन सा है? other than their coffee, it's croissant. So everybody naturally gets inclined towards it. मुझे croissant खाना है. Why? Because वो सुंदर दिखता है. Correct? So even bakery products पे भी, bakery products के भी aesthetic appeal पे आप design protection ले सकते हो. So industrial design recognizes the creation that is new and with original features. New in terms of shape, configuration, ornamentation, surface pattern, composition of lines or colors. Okay. Can anybody recognize this? Yeah, you're right. जोर से बोल सकते हो? Sabyasachi, yes. Any other guesses you guys want to do? Or shall we go with this guess? Sorry? Ritu Kumar is a very famous, sir. Ritu Kumar is more on the Western outfit side. They also have Indian labels as well. But the correct guess is Sabyasachi. Thank you so much for your guess, sir. Okay, so the design is Sabyasachi. अब आपको कैसे लगा कि ये Sabyasachi है? Why did you guess? How did you guess? Weddings, yeah. Okay, okay. All right. She's right. A lot of Indian celebrities or even foreigners for that instance, they go for the Sabyasachi lehenga. Now I'll tell you the peculiar features of these lehenga, okay? They have this red color going on, which is a very different earth tone of red color, which is only found in their design. Another thing is, when you see the lehenga pattern, it has a lot of motif work going on. Everybody understands motif, M-O-T-I-F. It's a very peculiar design, which is very much into Indian fashion. You see a lot of motifs in Indian fashion. I can see the lady in blue also wearing the same pattern. So that's the peculiarity of, that's how you identify a Sabyasachi lehenga. So, ye jo Sabyasachi lehenga hai, it is also protected under design. Why? Again, they have a very peculiar design. It is very different from others, and that's the USP for them. ये recognize कर सकते हो ना? What is this? The product towards your, I am very bad with directions and orientation. So the one towards your left, yeah. Can you identify that product? Yeah. क्यों use करते हैं उसको? इंडिया में हम क्यों use करते हैं? Sorry? हाँ, yes, for traveling. Any other purpose? अरे उसका मेन पर्पस ही नहीं बता रहे हो आप लोग. Yes, for advertisement. Yes, ma'am. Yes, absolutely. अब इसको हम बहुत डाउन मार्केट समझते हैं, राइट? हाँ, विमल की थैली डाउन मार्केट समझते हैं, काफी नहीं प्रेफर करते हम, राइट? But then one fine day when I was scrolling through Instagram, I came across this picture wherein a foreigner was using that bag. Yes, exactly, Vimal wala. And she was like, she wrote a nice caption also under it. The bag is very durable, very fashionable. It looks very nice and very street style aesthetic follow ho raha hai isme. And I was so shocked. भाई ये थैली को कोई पूछता भी नहीं इंडिया में. और एक फैक्ट बताती हूँ. कल के मेरे रिसर्च में मुझे पता चला कि ये बैग अराउंड आई कैन कन्वर्ट इट इनटू इंडियन रुपीस 2000 में बिक रही है. सेम थैली वहां पर यूएस में 2000 में बिक रही है. व्हाट इफ हम इंडियंस ने अगर विमल के बैग का डिजाइन प्रोटेक्शन करा लिया होता तो? वो डिजाइन का शेप, वो जो बैग का शेप है, the bag is very famous for that shape overseas, not for the Vimal branding. They don't even know what it is actually. अगर उनको बता दिया पान मसाला है तो again they might make a fool out of us. But then the design is, the bag is famous for its design. अगर हम इंडियंस ने सोचो या फिर वो विमल कंपनी वालों ने इसका डिजाइन प्रोटेक्शन लिया होता तो आज क्या ये लोग उनको स्यू नहीं कर सकते थे, राइट? कितना पैसा कमा सकते थे यार. That's how Westerners are doing, right? They are taking up our products and they are selling it as their own. ये एक एग्जाम्पल ने सबको जगा दिया पीछे, बहुत मस्त है ये. ओके, एनीवेज आई गिव ऑल क्रेडिट्स टू दिस एग्जाम्पल. Yes ma'am, I'm going to come to that as well. Okay. इनको कोई आइडेंटिफाई कर सकता है? I don't want answer from you. Anybody else from the crowd? मैं देती हूँ. Very famous model, very famous model. Recently वो headlines पे आई थी for two reasons. She was diagnosed with Lyme disease and second is बीच में ना there was this fashion show जहाँ पे this lady was standing all naked and the dress was 3D printed on her. This reel had went viral actually and the design received a lot of applause. So I want you guys, these are the basic two guesses, hints for you guys maybe. Now can you guess who is she? अबे model भी बता दिया. Any guesses? Two sisters है, एक का नाम जीजी है, दूसरे का नाम बेला हदीद. Yes, she is Bella Hadid. अब why is her picture on the screen? What has she done so much कि उनका नाम आ गया, उनका फोटो आ गया स्क्रीन पे? There is a reason. What is she holding? ऐसे हाथों में क्या लेकर खड़े हैं? This particular, क्या बोलते हो आप लोग? Okay, हम बोलते हैं उसको दुपट्टा, scarf, right? Correct? These people call it Scandinavian scarf. They call it Scandinavian scarf. They say that it's very aesthetic that way. We wear it that way. We pull it off. We are the ones who came up with Scandinavian scarf. Whereas, कौन है ये? ओके, इनको तो सब जानते हैं. प्रियंका चोपड़ा ने तो ऑलरेडी डेब्यू कर दिया था इसका. डू यू गाइज रिमेंबर द सॉन्ग लाल दुपट्टा? यस. सो वेस्टर्नर्स आर वेरी इनफेमस दैट वे. दे हैव ऑलवेज बीन स्टीलिंग स्टफ फ्रॉम अस. हमारा डिजाइन चुराते हैं और बोलते हैं कि कुछ तो भी फैंसी सा टर्म दे दिया and they project it as their own product and sell it off for dollars and make millions. That's the beauty of IPR. We don't protect it, so they use it. Yeah. Ma'am mentioned about the Kolhapuri controversy. किसी को पता है in detail क्या हुआ था ये? Anybody is aware? काफी headlines में भी था ये. Okay, I'll tell you. There is this fashion brand. Again, I won't name them. Okay, it's right on the screen. Anyway, so Prada ने क्या किया? एक बार they hosted a fashion show, and of course Prada is very infamous for stealing stuff from us Indians. Currently, they are trying to steal the pipe bag as well, which is used in South India. Pipe bag समझते हो? हम पुराने ज़माने में ना we used to carry those bags to temples or to, yes, right, pipe bags, yes. Currently, they are in the process of even stealing that idea. And I'm pretty sure Balenciaga or Prada will sell it for millions. Okay, so this controversy happened wherein हमारे यहाँ का, although I'm a South Indian, but then I can call myself as someone who belongs to Maharashtra. So हमारे यहाँ से ये concept चुरा के they presented it in their fashion show. Of course, थोड़ी ना मराठी लोग चुप नहीं बैठेंगे, हम तो आवाज उठाएंगे. So initially इतनी हवा नहीं बनी, but then power of social media, हर जगह ये बात फैल गई. everybody got to know कि अरे ये लोग हमारे ideas फिर से चुरा रहे हैं, तो Scandinavian scarf भी चुरा लिया, अब ये भी चुरा रहे हैं. That's how the fight began, and ultimately we won. We got a GI for it. Now, again I mentioned I'm a South Indian, okay? Every time I hang out with my friends or even my boss for that matter, anywhere I go to a South Indian restaurant, we order filter coffee, okay? And I always keep telling him, sir, ये वाला filter coffee नहीं है अच्छा. You should come to Malnad or you should come to Shimoga. वहाँ का filter coffee is the best. Now, why do I keep saying this thing कि वहाँ का ही best है? इधर तो इतने पैसे देकर पीने के बाद भी why am I not satisfied? It's because I'll tell you. The seeds, the coffee seeds that are grown in Malnad, which is very famous for their red soil, okay? So वहाँ के taste का जो वहाँ के coffees का जो चिकोरी content होता है, it is very intense or very dark. That's the reason David of coffee brand है एक. I am sure you guys are aware. Even they get their products from Malnad. That's the reason. So वहाँ के वो particular coffee का वो इतना अच्छा intense taste होता है ना. That's the reason कि वो coffee इतनी अच्छी होती है, which cannot match Maharashtra में जहाँ पर भी coffees मिलते हैं, filter coffees, they can't match to that level. That's the beauty of Malnad ka filter coffee. So any of you guys, if you visit there, visit Karnataka, please do try out the filter coffee. Can I request you guys to be seated? Yeah. Hello everyone, I'm Janvi Shetty. Yeah. Okay. तो अब बात आती है geographical indication की how is this related to the coffee वाला matter? Geographical indication जो होता है, it is always location specific. ये particular चीज़ यहाँ से अच्छी मिलती है, इसलिए इसका intellectual property उसी जगह को मिलनी चाहिए. Correct? So that's the reason why I keep telling कि sir filter coffee पीना है अच्छा तो वहीं पे चलो. That's the best. Why? Because the soil produces good quality coffee beans. So in a way, we are trying to do branding out of geographical indication. We know वो product वहीं पे अच्छा मिल सकता है. That's the reason we have GI. So GI is very specific to geographical origin. It is an origin-based protection, quality and reputation, and customer trust is gained. These are some of the very famous examples which are native to Maharashtra. Solapur ka chadar or Mahabaleshwar ke strawberries, very famous, right? These are the various GI, very specific to the location. I'll speak about Maharashtra. We have Paithani saris, Nasik ke grapes, and Solapur ka chadar. And of course, Karnataka is very close to my heart. Mysore silk hai, Dharwad peda hai, and filter coffee as well. Can anybody identify this website? Yes, slide share. क्या करते हैं ये website से? What do we do? Sorry? Okay. How many of you all are faculties? Can you guys raise your hands, please? Oh, all of us, okay. All of you guys, okay. आप लोगों ने आपके students को presentation बनाने के लिए दिया है? Right? Presentation बनाने को दिया है, right? Okay, I am also a student. I was also a student. Let me confess something very critical today. जब भी teachers बनाने देते थे ना presentation and end moment पे आता था, तो we used to download it from SlideShare. Okay. Oh, okay. Okay. So when I was a student, as in when I was in my B.Pharm years, AI का इतना बोल वाला नहीं था, तब हम स्लाइड शेयर से चुरा लेते थे स्लाइड्स और प्रेजेंट कर देते थे. इवन सारा असाइनमेंट्स भी यही से कर देते थे. Do remember the context. We'll come to the topic why I'm discussing this. Can you guess the movie? क्या डायलॉग चल रही थी ये टाइम पे? ओके ओके ओके. ये पता है कौन सी, एटलीस्ट नॉट द साउथ इंडियन मूवी बट हिंदी वाला मूवी जिसमें अनुष्का शर्मा और रणवीर सिंह है? ओके ओके फाइन. Back then I was a naive kid. I didn't know कि IPR exists. And अगर मेरे professors were very like sweet and nice, and they didn't mind much me copying from SlideShare. Otherwise मुझे बराबर copyright के नाम पे lessons मिलता. Yes, of course, it is not allowed, by the way. And if you are citing or if you are stealing any content from here, you are supposed to cite at least the website name or give due credits to them. That's important, which we often tend to forget. So all those kids out there, याद रखना, अगर कहीं से कुछ content आते हो तो reference में वो site का नाम ज़रूर लिखना, okay? All right. So since I see a lot of young people out there, YouTube देखते हो सब लोग? सब देखते हैं YouTube? कुछ कंटेंट क्रिएटर्स के नाम बता सकते हो जोर से? सॉरी, अरे बोलो, इट्स फाइन. टेक्निकल गुरुजी, यस. एंड सॉरी? ओह नाइस. मैम, कैन यू कम अगेन? हाँ, मैं भी देखूंगी. Even I want to check that out. Yes, any other YouTube channel? Yes. Sir, you're on YouTube. Oh, okay. In a very influencer style. Hey guys, welcome to Vinod sir's channel. Please do subscribe, like, comment, share his content. Please don't forget to click on the bell button. Okay. So coming back to my question. अरे पता होगा यार, इट्स ओके, डोंट वरी. फैकल्टीज कुछ बोलेंगे नहीं, बोल सकते हो. मैं गारंटी लेती हूँ, ऑल्दो मैं जाने वाली हूँ सेशन के बाद, बट ठीक है. आई कैन टेक अ गारंटी, कुछ नहीं होगा. बताओ कुछ यूट्यूबर्स के नाम. आशीष चंचलानी नहीं पता क्या? ही इज वेरी आउटडेटेड, बट ठीक है. Oh, nice. I learn a lot of cooking from her videos. Kavita's Kitchen? Yes? Okay. Sarita's Kitchen? Okay. And what else? Beer Biceps? Yes. बहुत controversy में फंस गए थे. Okay. Anyone else? Yes. Podcast, right? Yes, he does podcast. Yes. And who else? CA, yes, CA रचना रानडे, yes. And मुझे entertainment side से कुछ नाम चाहिए. Sorry? तन्मय भट्ट, yes. हाँ. Triggered इंसान, yes. Who else? समय रैना, yes. मृणाल ठाकुर, oh, yes. And who else? Okay. ये सारे जो यूट्यूबर्स हैं ना, इनको एक चीज का बहुत डर रहता है. क्या है वो? ऑलमोस्ट हर वीडियोस में दे कीप सेइंग कॉपीराइट स्ट्राइक आ जाएगा. क्यों आता है ये कॉपीराइट स्ट्राइक? व्हाई डज इट कम? कभी देखा है उसके पीछे का कॉन्सेप्ट क्या है? ये कॉपीराइट स्ट्राइक क्या होता है? नो, ओके. अब आप लोगों ने ये मूवी का डायलॉग बोला, राइट? कैन यू गाइस से इट लाउड अगेन? ये रिकॉर्ड हो रहा है ना? हाँ, ये क्लिप मुझे मिलेगा, राइट? ओके. मैं ये मूवी के प्रोड्यूसर्स या डायरेक्टर्स के पास जा सकती हूँ, ये क्लिप दिखा सकती हूँ, उनको बोलूँगी कि ये लोग है ना लाइव ऑडियंस में दे वर यूजिंग योर डायलॉग्स, तो वी कैन स्यू देम, 50-50 करते हैं. इनसे जो पैसे आएंगे मैं 50 रख लेती हूँ, आप 50 रख लो, अच्छी से कमाएंगे. Yes. So the audience is pretty smart. I cannot use that now. Anyways. Okay. So this guy says, Basanti in कुत्तों के सामने मत नाचना, right? उस टाइम पे this dialogue was protected. वो protection कहाँ से आई? Guys, please. कहाँ से आई? This can also be protected under copyright. अब let's come to this case study. Very interesting. सब कितने लोगों ने पुष्पा मूवी देखी है? पुष्पा, is it पुष्पा और what is it? Sorry? पुष्पा, yes. Part 1, Part 2 किसने देखी है? Part 1, Part 2? नहीं, okay. गजनी मूवी देखी है? Correct, देखी है ना? Ready movie देखिए. I was a huge Salman Khan fan back then. Please don't judge me. Okay, I am a Rakhi Sawant fan, so you guys can't judge me. Okay, please. All right. So you guys are already judging me. अरे नहीं यार, please ऐसा मत करो मेरे साथ. Anyways, okay. So all right. तो गजनी मूवी की है बहुत लोगों ने, राइट? सूर्यवंशम भी देखी है? ओके, ऑलराइट. सो बहुत सारे मूवीज का नाम जो मैंने लिया हुआ है ना, दे वर मोस्टली मेड इन साउथ इंडियन लैंग्वेजेस फर्स्ट एंड देन उनका रीमेक किया गया है. नाउ हियर देयर वाज नो ऑब्जेक्शन एज सच from both the parties. Why? Both had a legal contract something जिसमें they agreed on mutual terms कि yes you can use our movie के dialogue, songs और lyrics और even scene का cut भी same to same आप use कर सकते हो, we don't mind. Okay? But ये इस केस में ना उल्टा हो गया. जनरली साउथ को कॉपी किया जाता है, बट यहाँ पे श्री साई गणेश प्रोडक्शंस ने ना कोशिश की टू कॉपी द एग्जैक्ट सेम मूवी बैंड बाजा बारात. समंता पता है ना? एंड द अदर गाय यू नो हु इज ही? सिद्धार्थ. ओके, सो दीज टू पीपल वर देयर इन द मूवी एज द मेन लीड्स और ये पिक्चर बनाई गई. जब ये पिक्चर रिलीज हुई ना तो यशराज फिल्म्स ने इनको स्यू किया. व्हाई? हमसे परमिशन नहीं लिया था, आपने अपने आप बना लिया ये मूवी, हमको तो पता ही नहीं है. एंड इनके बीच में एक्चुअल में केस हुआ था और ये जो पूरा डिस्कशन था ना, इट वाज अलोंग द लाइंस की मूवी का एक एक फ्रेम कॉपी किया गया है. डायलॉग, लिटरली डायलॉग्स भी कॉपी किए गए हैं, कॉस्ट्यूम्स तक सेम थे. सो जो जजमेंट था ना वो यशराज फिल्म्स के फेवर में आया एंड ये मूवी ज़्यादा चल नहीं पाई बिकॉज ऑफ द कंट्रोवर्सी. सी, दिस इज द पावर ऑफ इंटेलेक्चुअल प्रॉपर्टी राइट्स. अगर कोई आपके पास आके आपके ही राइट्स लेने की कोशिश करता है तो यू कैन एक्चुअली उनका बैंड बाजा बारात बजा सकते हो आप लोग. सो व्हाट ऑल कैन बी प्रोटेक्टेड अंडर कॉपीराइट? एनी आइडिया? स्क्रीन पे है, बट आई वांट द क्राउड टू लेट मी नो व्हाट ऑल कैन बी प्रोटेक्टेड. या कंटेंट, यस. Visuals, yes. What else? Design, nahi, ma'am. Design is separately protected under design registration. Trademark. Okay. Guys, we missed out on a very important or a very crucial aspect. Okay. For instance, ये जो भी ये सर यूज कर रहे हैं ना, सर आप दोनों का नाम क्या है? ओके, मिस्टर मंगेश एंड मिस्टर जिग्नेश. बाय एनी चांस आर यू गाइस ब्रदर्स? ओके, नहीं वो राइमिंग वर्ड्स कर रहा था इसलिए मैंने पूछा. सॉरी. Okay. So these guys are working on a setup. आप लोग मुझे I don't know about setup, but आप लोग बता सकते हो उसको overall क्या बोला जाता है? Sorry?
You can call it console actually.
सबको बता सकते हो?
You can call it console. It has been made with multiple devices actually. We are using YOLO box and PC, which is we are using YOLO box. It's a streaming device, and also we are using PC, which is connected to projector, so it projects your PPT. Yeah.
Thank you both of you. कुछ नया सीखने को मिला again. अच्छा ठीक है, ये सब तो आपने बता दिया, बट आप ये किस बेसिस पे ऑपरेट करते हो? कुछ सॉफ्टवेयर होगा, राइट? तो व्हाट इफ आप लोगों ने ऐसा खुद का ही एक सॉफ्टवेयर बना लिया, तो आप लोग क्या करोगे आगे? ओके प्लीज, आप बहुत अच्छा पॉइंट बोल रहे हो. आई थिंक यू शुड से इट.
We can plan to sell that software and claim the AMC's annually charges like something.
Okay, so you said you are trying, you would sell it, right?
Yeah.
वहाँ मेरे सर बैठे हुए हैं. Okay. Now what he does is, he is a gentleman. Okay, he is not like me. हम दोनों ही पेटेंट एजेंट है. Okay. These guys come to me. Now business का कीड़ा तो blood में है यार. Of course I'll look for my profits, right? I see that their product is very promising, very promising. What do I do? Sorry? Anybody? No, helping का नेचर है ही नहीं. यहाँ पे नहीं है, वहाँ पे है. वो helping का डिपार्टमेंट वहाँ पे है. Okay, so what I do is, अरे ये तो बहुत तगड़ा प्रोडक्ट है, मैं क्या करती हूँ इसको, I'll go to some nice tech companies और इसको वहाँ बेच देती हूँ. But then, two sides, huh? These guys also go to sir. Okay, and now sir being a nice guy, he tells them, कॉपीराइट का प्रोटेक्शन ले लो, सेफगार्ड करो, फिर किसी कंपनी के पास जाना. ओके, तो आपको क्या लगता है आइडियल तरीका क्या है सर? किसके पास जाओगे आप? कॉपीराइट प्रोटेक्शन के लिए जाओगे, राइट? सो याद रखना, इन केस इफ यू आर कमिंग अप विद सम न्यू एप्लीकेशन और सॉफ्टवेयर, उसके जो भी कोड्स होंगे या एल्गोरिदम्स होंगे, योर मैम इज द टाइम अप? ओके, sorry. So you can safeguard it using copyright. Okay, so algorithms, again algorithm and anything related to software, आपके codes भी होंगे, because I am a bit aware कि यहाँ पे Polytechnic के भी students हैं, so you guys should know the differentiator. अगर आपके पास कोई device है, proper device है, तो उसका overall device का या kit का it goes under patent protection. बट अगर उसमें कोई एल्गोरिदम्स इन्वॉल्व है या सॉफ्टवेयर्स इन्वॉल्व है, सॉरी, यस सर, सर्किट डायग्राम, यस. सो डायग्राम यू कैन गो फॉर कॉपीराइट प्रोटेक्शन, यस. So all this can be protected under copyright. Audio, literature, architecture, video and film, choreography, even the dance moves that you choreograph for your annual day function can be protected under copyright. Yes, ma'am. Ma'am, the designs. Yes. Sorry? Yes, the plan layout can be protected. Right, sir? Sir, under architecture, what can be protected? So the designs and the plan can be protected. Copyright, yes ma'am. Yeah, we have a YouTube. Sir, आपके जैसे हमारा भी YouTube channel है. Please do subscribe to our YouTube channel. It's Pharma Literati. ये सारे लोगोस को जब पहचानते हो, पहचानते हो ना सारे लोगोस? कहाँ कैसे प्रोटेक्ट करोगे? लोगोस है तो ट्रेडमार्क. यस, वेरी नाइस. So under trademark, you can protect logos, you can protect brand names, slogans, symbols, and everything related to that. Okay. So classic example. I think I should move there. Guys, please move faster. Hello again, I'm Janvi. Hi guys, to the new audience. Okay, so what exactly is about this trademark? So there is this classic example of embossing. अगर आप देखोगे तो जो tablets होते हैं ना उसका print देखो towards your left side of course. The print is so clear towards your left side and the right side, both of it. अगर आप देखोगे ना प्रिंट के ऊपर से या लेटर्स कैसे लिखे गए हैं, एम्बॉस्ड किए गए हैं, उसके बेसिस पे भी यू कैन आइडेंटिफाई कि कौन सा प्रोडक्ट फेक है और कौन सा ओरिजिनल है. बीच में ये डीमार्ट के साथ बहुत ज़्यादा चल रहा था, wherein there were many biscuit packets और टी पाउडर और इवन लिप्टन ग्रीन टी का प्रोडक्ट एज वेल. आप लोग कभी अभी तो दे हैव स्टॉप डूइंग दैट, बट इन बिटवीन देयर वाज दिस केस wherein फेक प्रोडक्ट्स रखे जाते थे. फेक नहीं मतलब द प्रोडक्ट विच आर अंडर क्वालिटी, ऐसे क्वालिटी वाइज 1, 2, 3 लेवल्स पे जाते ना, वैसे टाइप के भी प्रोडक्ट्स रखे जाते थे. So how did they identify that? How were the people being able to identify that? It was because of the these embossed characters या फिर जो लिखे हुए रहते हैं logos वगैरह, उसके basis पे they could identify कि कौन सा real था and कौन सा fake था. So again, be very aware. Next time you buy a product, please do take care of it. अभी ये I'll tell you a very simple example. I've been using this lipstick for इसका expiry by the way 3 years का है, okay, before you guys judge me again after that Rakhi Sawant joke. So I've been using this lipstick for 1 year now, okay. इसके ऊपर लिखा हुआ है Shiseido. It did not erase. No matter मैं कितना भी इसको गिरा दूँ, कैसे भी, even if I scrub it off, it won't go off. That's the beauty of the product identification or the product branding, I can say. I can easily differentiate. Just because I've used a authentic product, next time market में अगर कोई fake product होगा ना, I can easily identify. अब I'm sure all the females out here, even males for that matter, आजकल ना ये काफ़ी ज़्यादा trending है, sneaker head होना, sneaker head. पता है क्या? Okay, I'll tell you. Gen Z people, especially guys, not the girls here, guys, they are very fond of collecting this expensive shoes. 20-25 हज़ार रुपए चले जाते हैं. जितने भी पेरेंट्स बैठे हुए हैं ना, आज जाके अपने बच्चों के बैंक स्टेटमेंट चेक करना. अगर 25-30 हज़ार का ट्रांजैक्शन होगा ना, of course, if the guy is spending 20-25,000, it's for sure for a shoe. So ये ट्रेंड है स्नीकर हेड बनने का, ओके. सो वेरिन दे ट्राई टू कलेक्ट दीज वेरी नाइस शूज हो गए, ब्रांडेड शूज हो गए. आई हैव अ फ्रेंड हु इज अ स्नीकर हेड, ओके, एंड ही लाइक्स टू परचेज दिस एक्सपेंसिव शूज. मैं और वो एक दिन हिल रोड पे चलकर जा रहे थे, and we could find the exact same shoe which he bought for 32,000 rupees being sold at, any guesses? 300 rupees, yes. 300 रुपए में बेच रहे थे. उसकी तो जान ही जल गई. उसने लिटरली निकाला और इंस्टाग्राम पे पोस्ट किया, देखो ये चल रहा है करके. एंड दैट्स व्हेन आई टोल्ड हिम, हाँ तुझे तो नहीं पता, ये सब मुझे ऑलरेडी पता था. दैट्स द ब्यूटी ऑफ IPR अगेन. ओके ओके अगेन फोन चार्जर्स पे भी. नेक्स्ट टाइम ना व्हेनेवर यू बाय अ प्रोडक्ट, ओके, कहीं से भी ले रहे हो, इवन इन अ स्मॉल शॉप और सो, मेक श्योर कि आप गूगल करो वो पर्टिकुलर प्रोडक्ट के बारे में, उनके साइट पे जाके चेक करो इफ यू वांट टू एक्चुअली बाय द ऑथेंटिक प्रोडक्ट्स. ओके, check on their site. How do they represent their product? How is their logo? How is it placed? Where is it placed? Even that is important. Okay, उसके basis पे you buy your product. Sir, I'm not aware of that news. Yes.
We used to sell products which were having names very near to Reliance products. So Reliance has complained it and now they have to remove it from that. So online the Instamarts वगैरह ना those they have to remove those products.
That's a wonderful information. I was not aware of it. Please sir के लिए तालियां बजाओ यार. He has actually shared a very nice bit of information. Sir, मैं अपने next session में ये information use करूँगी. Thank you so much. हाँ चलेगा. मेरी बिल्ली मुझसे ही मियाओ. Okay, again मैंने अभी आप लोगों को बताया before you buy a product, maybe check for your product कि कैसे उसको represent किया गया है, कैसे उसके logos को represent किया गया है. You can see a vast difference. देखो वो cheap one का जो है ना, it's already faded out, whereas the original one एकदम मस्त मैक करके लिखा हुआ है. Trade secret. What is it about? कोका-कोला का रेसिपी है. किसी ने कभी रेप्लिकेट करने का ट्राई किया? See, I am very fond of this experimenting with stuff. Okay, I can mix coffee with tea and check उसका टेस्ट क्या है. तो वैसे मैंने ये ट्राई किया, but I failed, and after that my mom banned me from entering the kitchen for almost a week or so. Disaster था वो. Why can't I replicate it? Any idea? Sorry, ma'am? Yes, formula. So that particular formula is only known to those people. So it's basically protecting your recipe and not letting others know. Okay, so again, ये सारा सब कुछ जो भी है ना, it's all about branding. आपका प्रोडक्ट आपके पास है, फॉर्मूला आपके पास है, थोड़ा बहुत ट्वीक करके लोग लेकर आ जाएंगे, बट कैन यू रेप्लिकेट द एग्जैक्ट प्रोडक्ट? नो, राइट? सो उसका प्रोटेक्शन कैसे मिलेगा? दैट विल बी अंडर ट्रेड सीक्रेट. कमिंग टू अ वेरी, सॉरी, yes, legit papad. Yes. Till date, my household people couldn't replicate the papad. Anyone from the crowd who could actually come up with the recipe? अगर कोई है तो please मुझे बता दो. I'll share my contact details. I would like to try that. Okay. Sorry, ma'am. Oh, okay. Okay. Yes, ma'am. Okay, so ma'am is talking business now. Nice. Oh, it's in your blood as well. Nice. Okay. So let's move on to a very important topic which is close to my heart. Patents. अब मैंने बहुत बोल दिया था पहले ही पेटेंट का. ये लिपस्टिक में ये चीज़, ये पार्ट आप पेटेंट करा सकते हो, वो पार्ट आप पेटेंट करा सकते हो. बट व्हाट इज इट एग्जैक्टली अबाउट? डिजाइन और पेटेंट के बीच में ऑफन पीपल आर वेरी कंफ्यूज्ड. व्हाई सो? अब तो कंफ्यूजन नहीं होना चाहिए बिकॉज आई हैव ऑलरेडी क्लियर्ड इट. सो लेट मी अगेन कम अप विद द सेम थिंग. डिजाइन जो दिखता है वही बिकता है, एक्सटर्नल अपीयरेंस पे रहता है. ओके, मैम ने इतनी सुंदर साड़ी पहनी है, वो डिजाइन प्रोटेक्शन पे चला जाएगा. बट व्हाट अबाउट दिस माइक? व्हाट इफ ये माइक पहली बार किसी ने बनाई है, पहले किसी को पता ही नहीं था. देयर इज अ फंक्शन दैट गोज ऑन इनटू दिस, राइट? और फॉरगेट दैट, ये एक लिपस्टिक, इसका आप अगर देखोगे ना, दिस इज अ वेरी स्मूथ रोटेटिंग पैटर्न. generally I've used a lot of cosmetics, but I can tell you इतना smooth rotation ना मुझे किसी product में मिला नहीं है. Even इसके पीछे ना बहुत बड़ा tech होता है, which generally we underestimate. ये छोटी छोटी चीज़ें आसान हो पाती है. There is a reason behind that. If you guys are aware, तो सेलेना गोमेज पता है सबको? सेलेना गोमेज back at the back, you guys are aware, right? Who is she? Singer. Okay. She suffers from a health condition. What is it? इसका थोड़ा बेस कम कर सकते हो क्या? She suffers from a condition. Hello. हाँ, perfect. Yeah. So she suffers from a condition. What is it? Any idea? मैम आप गूगल कर रहे हो क्या? Okay. Anyways, she has this autoimmune condition which is known as lupus. Okay. Lupus में क्या हो जाता है? Patient के पास सर इसका थोड़ा base का adjustment yes, yeah. So she suffers, yeah, this is much better, thank you. So she suffers from a condition which is known as lupus, wherein daily life के activities करना becomes very difficult, very difficult. हाथ हिलने लग जाते हैं, pain होता है, there is a constant pain in your body, you have to take so many steroids just to combat that pain. Again, she is an excellent inventor. Very excellent inventor. If you guys are not aware, maybe you can check out Selena Gomez का product. Product का नाम क्या है? Any idea? Rare Beauty, right? You go and check out her products. She has patents even for her cap. वो जो particular cap है ना, वो इतना user friendly है कि any person who is suffering from arthritis or any lupus sort of condition, they can easily open or close the lid of the product. So again, there is a tech involved, right? तो वहाँ हम फाइल करते हैं पेटेंट. समझ में आया? अब आप लोग पूछोगे ठीक है ये मैकेनिक्स का तो समझा, आप बोल रहे हो कि पेटेंट फाइल कर सकते हैं, बट आपने ऐसे क्यों बोला कि ये लिपस्टिक का फॉर्मूला के ऊपर आप पेटेंट फाइल कर सकते हो? व्हाई इज इट सो? एनी आइडिया? अगेन, ये जो लिपस्टिक का फॉर्मूला था ना, जैसे मैंने स्टार्टिंग में आप लोगों को बताया था, बेटर एप्लीकेशन, स्टेज फॉर अ वेरी लॉन्ग टाइम, स्मज प्रूफ है, लुक्स वेरी नाइस, डजंट इच मी. That's my main concern. I am very sensitive to these makeup products, so I have to be very cautious whenever I choose something. This doesn't itch my skin. So ये सारे features जो है इस प्रोडक्ट के, ये आए कैसे? आपको पता है लिपस्टिक कैसे मैन्युफैक्चर होता है? आई एम नॉट अ सूटेक्स पर्सन, सर इज द वन हु डील्स विद सूटेक्स, बट मुझे थोड़ा सा आइडिया है. ओके, बेसिकली व्हाट हैपेंस इज, ये प्रोडक्ट बनाने के लिए देयर आर सर्टेन इंग्रेडिएंट्स, बीज वैक्स वगैरह यूज किया जाता है, वैक्सेस यूज किए जाते हैं, देयर आर पिगमेंट्स विच आर यूज्ड, प्रिजर्वेटिव्स यूज किए जाते हैं. ये सारी चीज़ों का एक कॉम्बिनेशन बनाया जाता है. अलग अलग इंग्रेडिएंट्स पे टेस्ट चेक किया जाता है कि किस पे उसका फ्लो प्रॉपर्टी कितना अच्छा है या फिर उसका पिगमेंटेशन कितना अच्छा है. सो देयर इज एन एक्चुअल रिसर्च दैट गोज ऑन जस्ट टू कम अप विद द पिगमेंटेशन और विद द एप्लीकेशन, कितना अच्छे से अप्लाई हो रहा है वो प्रोसेस के लिए. सो अगेन वहाँ पे एक्चुअली पीपल आर यूजिंग देयर ब्रेन्स, दे आर यूजिंग देयर साइंटिफिक नॉलेज, राइट? टेक यूज कर रहे हैं वहाँ पे टू कम अप विद दैट पर्टिकुलर फॉर्मूला. अगेन एक बार वो फॉर्मूला बन जाता है, आजकल दिस इज वेरी डिबेटेबल बट इट स्टिल गोज ऑन इन इंडियन मार्केट. यूएस यूके में अलाउड नहीं है, एनिमल टेस्टिंग होती है. इट्स वेरी क्रूअल, बट देन व्हाट हैपेंस इज एनिमल्स के ऊपर लगाया नहीं जाता. बाय द वे देयर इज दिस मिसकंसेप्शन, जैसे हम अप्लाई करते हैं वैसे एनिमल्स को अप्लाई करते होंगे, ऐसा नहीं है. These products, since I'm a pharmacologist, I can tell you how it works. These products are actually mixed in some solution and they are given via IV to those animals. Actually उनको disease conditions तक induce किए जाते हैं और फिर इसको apply किया जाता है ताकि ये देखा जाए कि मेरे जैसा इंसान who is very sensitive to makeup products उसकी skin को कितना bother करेगा करके ये भी check किया जाता है on those animals. Again, all this requires an actual research, right? ये एक फॉर्मूला डिजाइन करने के लिए प्रॉपर रिसर्च हुआ है wherein ऑप्टिमाइजेशन हुआ है पूरे प्रोडक्ट का, लेटर एनिमल स्टडीज हुआ है, प्री क्लिनिकल ट्रायल्स किए गए हैं, ह्यूमन ट्रायल्स किए गए हैं, एंड देन द प्रोडक्ट इज लॉन्च्ड इन द मार्केट विद अ ब्रांड नेम, राइट? सो ऑल दिस टेक, ये जहां पे भी पूरा आपका इंटेलेक्ट यूज किया गया है, अगेन देयर इज अ साइंस दैट इज इन्वॉल्व्ड, हेंस ये वाला जो फॉर्मुलेशन पार्ट है इट गोज इनटू द पेटेंट प्रोटेक्शन साइड. अभी समझा व्हाई लिपस्टिक का शेड या वो लिपस्टिक का फॉर्मूला was protected under patent application? Any doubts in this? Sure? Okay. So patent protection generally आपको मिलता है based on functionality and science. Okay? कोई आज के बाद बाहर जाके ये नहीं बोलेगा कि डिज़ाइन पेटेंट फाइल करना है. आप बोलोगे इंडस्ट्रियल डिज़ाइन रजिस्ट्रेशन कराना है, डिज़ाइंस रजिस्टर होते हैं और पेटेंट्स फाइल किए जाते हैं जो आगे जाके ग्रांट होते हैं. यस सर, यस सेम. ओके, सो पेटेंट राइट्स आर वेरी एक्सक्लूसिव राइट्स, जुरिस्डिक्शन स्पेसिफिक होता है. देयर इज एन इन्वेंटर और असाइनी. मैंने आपको स्टार्टिंग में बताया था एप्लीकेंट और इन्वेंटर्स के बारे में, करेक्ट? नेक्स्ट, देयर इज डिस्क्लोजर ऑफ इन्वेंशन. इट इज फॉर लिमिटेड पीरियड ऑफ टाइम. टर्म इज 20 years. So again the same, yeah. Okay, so I want to conclude on a very nice note. मेरे सर का फेमस डायलॉग है ये, विद जो मैं भी यूज कर रही हूँ अभी. वन प्रोडक्ट कैन हैव मल्टीपल IPRs. क्या अब आप कन्विंस हो गए या फिर मैं और बोलूँ? पक्का? ये डायलॉग कहाँ से है, चलो गेस करो. यस, वी मेट गीत सेज दिस डायलॉग टू द रेलवे का गाय. क्या आप कन्विंस हो गए या फिर मैं और समझाऊँ या और बताओ? So that's it. One product can have multiple IPRs, but it depends on you what you want to go for. If you see there is a utility or there is a functionality in your product, please do go for patents. अगर आपको लगता है आपका प्रोडक्ट बहुत सुंदर है, बेच सकते हो ऑन द बेसिस ऑफ एस्थेटिक, गो फॉर डिज़ाइन. आपको लगता है कि आपके प्रोडक्ट का एक लोगो होना चाहिए तो गो फॉर ट्रेडमार्क. मेरे जैसे इंसान को हायर कर लो, फ्री में मार्केटिंग कर दूंगी. ओके, मेरी जो भी स्क्रिप्ट होगी उसकी कॉपीराइट करा लो. दैट्स इट. Yes sir, yes, absolutely, yes, yeah. Okay guys, with this I end my presentation. I hope I did not bore you guys. Okay, yeah. Thank you so much. आप चाहते हो कि मैं बहुत ऐसे इससे बोलूं? Guys, please, 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 it's a request to all of you. Kindly fill the feedback form, right? Yeah. Kindly fill the feedback form. It's very necessary. Otherwise, मैम लेके सू करेंगे, कोर्ट पे लेके जाएगी हाँ सबको. Please fill करो फटाफट. Thank you.
But then since this is part of the discussion, what I will be doing is I'll try to connect it with the entire, I would say the setup of the entire faculty development program, as well as the previous session, the earlier session or the inaugural session, as well as I would say the questions that were asked in between as such. We have been trying to learn about IP since morning as such. But can you simply, let us try to make it a bit interactive as well. Can someone actually tell me what do you mean by intellectual property rights and why are we here? Of course, that was the question asked in the morning. Why do we need to learn these things basically as faculties or let's say as students basically? What is intellectual property rights for you? Of course, beyond NAC and NIRF rankings. What is the significance of that? Or what do you mean by that? How is it relevant to our life basically? All of you have got phones? They're on silent mode? Yes? Anyone has got iPhone? Can I have it for a minute? Is this yours, ma'am? How can you say that? Oh, this is in my hands. How can you say that you own this? A password, right? Oh, just someone actually like, you know.
My photos are there in it, so that's why I can claim it's mine. Like that.
Oh, just for your information, मेरा introduction बहुत ही like you know छोटा सा था. I am a just 1 second, sir. I am an ethical hacker. I just need 45 seconds to crack your password. I just need 45 seconds to get access to everything that you have in your phone. Are you worried? No. Go ahead. Someone said go ahead. Okay. How can you say that you own this? It's in my hands. It's mine. IMEI number. Okay, you have the bill basically. Thank you so much, ma'am. Yeah, of course, you own it. I don't own it actually. Like, you know, that's all yours as such. The bill acts as a proof for what you actually own. That's a legal proof basically. Like, you know, if you lose your phone when you go to police, that point of time, maybe you need to prove first that you owned it as such. Right? That works as a legal proof. We call this generally as a tangible asset. So, which can be valued, which can be seen as well. Can I have a pen, please? Is this yours? Now it's mine. Why is it so? It's in my hands. It's mine. Do you have a bill for this? Why so? Pardon? Acha, gifted hai. Valuation? Valuation is less. That's the reason we don't need a bill or legal proof. Arey, chalo kho gaya, 10, 20, 50 rupees ka pen hai. I'll buy the another one actually. Right? Of course it's yours, don't worry. Now, think of your ideas in the same context. Think of your research, what you are doing. Think of those research project or thesis in your fashion department, jewelry department, home science department, food tech department, electronics department, or you know, chemistry, microbiology, biotech. The project on which you are working, can it have a value first of all? There was a question about patent commercialization in the morning. Like why the patents are not commercialized. Well, I'll try to answer it right here as well. Does your thesis have a value? What value? Oh, by the way, I'm also a lawyer. If you say yes, you have to justify. Actually, the thesis, what happens to the thesis? Like, you know, library mein chala jata, you submit it, you get a degree. What happens to it thereafter? Is there a value? Okay, let me put the word value in different terms. Does it have a commercial value? Patent to main bol hi nahi raha. Does it, simple answer, does it have a commercial value, yes or no? Haan? Haan? Yeah. Yeah. Why don't you do that then? Okay. Let's think of the, since the event is organized by SNDT University, PV Polytechnic, we have one particular stream called jewelry design, right? any projects the students who are actually doing, does it have a commercial value? It may have. Have we tried it out? The fashion design department actually goes for a fashion show every year, right? There may be some value. There is an inherent value. Probably we are not the right people to evaluate it. We are not the right people who understands the value of it basically. हमारा काम ये है from a teacher actually is to do research basically. Fundamentally, that's what you are actually involved into. As a researcher, we need to understand one thing. We can do, let's say, good research, but we may not be in a position to understand the critical value of the research. We need to understand that when your ideas have a value, the moment आपके स्टूडेंट्स ने जो ज्वेलरी डिज़ाइन के ज्वेलरीज बनाए हैं, फैशन डिज़ाइन इंस्टीट्यूट के स्टूडेंट्स ने जो प्रोजेक्ट्स किए हैं, जो फूड साइंसेस फूड टेक के डिपार्टमेंट के बच्चों ने जो थीसिस किया है, दैट फूड प्रोडक्ट, if it has a value at that point of time, do you want to give it away like she is willing to give the pen? And that's where comes the concept of intellectual, that intellectual creativity is there, जो हम thesis कर रहे हैं, whatever we are doing, everything is intellectual creative activity. But problem is with the second word, is it a property or not? Firstly, we don't know. We never tried to evaluate it as well. We don't have time to do that as well. The moment intellectual becomes property, you need legal rights for that. The moment your intellect becomes a property, that point of time, you need legal rights for that. That those rights, we as IP attorneys or patent agents try to get it for you. That means, who gives this right? IPR agent. Oh, if I was the one who was giving the right, I would sell, I'm a businessman. Exactly. The government of India gives the right. The IP office, and the gentleman we had in the morning as a chief guest, he represented IP office, Intellectual Property Office. Now I have a question in terms of course we had a wonderful session by my colleague Janvi, wherein she mentioned about different types of intellectual property rights. But the question is, do we really need different types of IPs? Why so? They are different the creativity, the intellectual creativity. Let's say Gulzar Saab just needs one day to write a song, let's say, but then probably a PhD researcher requires 7 years to finish PhD. Can you compare them? A fashion designer may require a lesser time. A software developer may require 1 year time to develop and taste and actually come up with the product. The way we have different types of creativities, all these creativities are falling under the first thing, that is intellectual creativity. Right? Since we have those different types, that's the reason we have different types of intellectual property rights. And the intent of the first session was, of course, to actually understand the differences between different types of intellectual property rights. Look, quickly going back, what are those different types of intellectual property rights? What we have studied since morning? First one is design. Design is meant for external appearance. External or physical appearance. How it looks basically, correct? Aesthetics, absolutely correct. Now, What are the industries which are dependent on industrial design? Fashion is the first one. Jewelry is the second one. Cars, someone said that. Mobiles, right? Pardon? How come? Chemical industries में shape का क्या constraint? No, those are not, okay. Now, that's the reason I wanted to revisit this. The structure of benzene, let's say, or the structure of naphthalene. Plant, as architecture goes into copyright. Design, I'll tell you simple, one thing we need to understand, the designs, the applicability is in terms of products only, right? So architectural design goes into actually copyright and not into the industrial design. I'll give you one simple example everyone can connect to, just to refresh how the different types of IPs work. Industrial design, simple language mein batata hu. I can see a lot of females here, right? Rather, we have hardly 10% males here. Females, all of you love shopping? You go for shopping? Very frequent? Even males, you have that opportunity at times, right, sir? Right, sir? Okay, now, very rarely, I also get this opportunity to go for shopping with my very own wife. And you know, what happens, so the last time I went for shopping was 17 years back. That was the first and last time. That was to buy a sari, okay? Or sari, so most of you, if you go for shopping, shopkeepers ka patience level epic rehta hai. Am I correct, ma'am? Right? Now, they are being asked a lot of questions actually. Can you tell me what are those questions or what are those things the purchaser or the buyer asks to the shopkeeper or jo banda aapko sari dikha raha hai? इस कलर में वो डिजाइन दिखाओ. वो that design part, am I correct, sir? Right, sir? You also have experience like me. Now, patents? Patents are generally for only, try to understand this. I get questions like we have been filing IPs, a faculty comes to me, sir, मेरे ये डिजाइन का पेटेंट का कॉपीराइट करवाओ. These are very frequent. Day in, day out, I have to hear this. मेरे पेटेंट का डिजाइन का कॉपीराइट करवाओ. This is like telling, I'm telling the address, SNDT आना है. अच्छा, मुंबई में एक चेन्नई करके लोकेशन है, उसमें एक सबब है, उसका नाम कोलकाता है, वहां पे आना है आपने. That's how they are different actually. They are not at all interconnected. IPR, intellectual property rights, as we say IPR and patent, actually IPR is a broader umbrella. And there are different types of IPRs. First, industrial design applicable to fashion, jewelry industry, anything, any look of a product basically. From mic to pen to everything can be protected under industrial design. As far as patents are concerned, understand this, patents are only applicable in case of scientific inventions. Research-based scientific inventions, which means only science graduates और साइंटिफिक रिसर्च, आपका जो भी मास्टर्स प्रोजेक्ट है, आपका जो भी पीएचडी का रिसर्च है, दैट कैन बी द पीएचडी फ्रॉम आर्ट्स कॉमर्स कैन नॉट बी, दोज रिसर्च कैन नॉट बी प्रोटेक्टेड अंडर पेटेंट. एनीथिंग फ्रॉम द सॉफ्टवेयर कैन नॉट बी प्रोटेक्टेड अंडर पेटेंट. या no, so okay, I think the word design has broader meaning in multiple different industries. When we say design, it is an industrial design. That's where I said, show me the product and how it looks. That's when the applicability of industrial design comes into play. Classroom. Okay, I'll tell you how do we file the design actually. ये product है, we provide, just like in patent we have claims, इस product का we have to submit multiple looks. How does it look? Front, top, back, bottom, side, 3D view. ऐसे दिखाना है. It has to be a product only. Of course, we have a special session on industrial design. उसमें all 32 classes किस product का design मिल सकता है, that would be discussed later. Let me come back to my topic. Okay? What we studied? Design किस चीज को मिलता है? Patent. Patent is for research-based industries. Whatever research-based industries are pharma, life sciences, chemical. Someone had said chemical, biotech, automobile, mechanical engineering. Whatever you see as a research-based invention, वहाँ पे there is an applicability of something called as a patent. This is the second type of IP. The third type of IP we saw is GI, geographical indication. We saw those example, Mahabaleshwar strawberry se leke, Yes. I have a question here. Can Mumbai Vada Pav be protected under GI? So what? Who said that? Firstly, it's not patent, it's a GI. Why? Rather, I'll tell you the beauty of GI is that GI is the only type of IP जहाँ पे novelty नहीं required है. Mahabaleshwar strawberry सालों से आ रहा है, right? It's since ages. Kashmiri saffron pashmina is there since so many years. Rather, this is the type of IP जहाँ पे novelty नहीं required. Can? Yes. So can Mumbai Vada Pav be protected? Yes? Okay. Someone said no. It's not something? Okay, wonderful. Kolhapuri chappal, naturally grown? Come on, class. Can we protect Mumbai Vada Pav? Come on. Simple. अगर ये इसका आंसर नहीं दे पा रहे, I'll tell you an interesting thing. Delhi में एक जगह है. Next time you go to Delhi, I'll send you the address. I'll also pay for the vada pav once you go there. Actually, that tastes better than Mumbai vada pav. Come on, class. Now tell me, can we protect Mumbai vada pav under GI? What is that unique formulation? Can you? Okay. Let me honestly tell you. And now this is what happens when we think of GI or different types of IP. Okay, students and teachers, you are allowed only to speak to me. Okay, if you have any questions or answer to me. Okay, one thing. GI as a concept has applicability under 3 conditions. The first condition is the quality of the product has to do with local soil. Examples, Mahabaleshwar strawberry, coffee beans, what she said, or let's say the Himachal apple, or Darjeeling tea, let's say, right? रुकिए मैम, आप बहुत आगे भाग रहे हो. मुंबई का वड़ा पाव has anything to do with soil? पहले तो बता मुंबई में soil बचा है क्या? So, first category is ruled out, but what are the examples? Mahabaleshwar strawberry hai, Devgad hapus and Konkan hapus have different tastes. They are unique, right? There is a place called Malihabad in UP. Malihabadi Dasheri Aam is very famous actually. There are at least, I would say, pan-India, so many varieties of mangoes which are unique in its own. All of them get GI. Soil ruled out for vada pav. नेक्स्ट इज द क्लाइमेट. मुंबई वड़ा पाव का मुंबई के क्लाइमेट से कोई कनेक्शन है? Agreed? Now the same products what we say, Mahabaleshwar strawberry or Nagpur oranges, वहाँ पे climatic conditions help them grow that way, and those they give the unique taste to it. Right? That's the reason. So where is the applicability of GI? Geographical indication, naturally grown products for soil and climate, as well as I would say a lot of agricultural products. Now I'll tell you about the third category. The third category is when a local skill set has that uniqueness. For example, Kolhapuri chappal, there are local artisans, or if you go to Kutch in Gujarat, we have this Kutch embroidery. Yes, ma'am. Paithani sari. There are local, yes, someone said that Banaras? Banaras is silk or saris, right. Now the coming back, so there are n number of products we can actually speak of this. Pardon? I didn't get you, sir. Bandhani. That's in which place? So, okay. Now, the uniqueness is with respect to geographical location and then either its climate, soil, or the local artists. Now, Mumbai Vada Pav, first two categories ruled out. Is it that जो मुंबई में वड़ा पाव बनता है, is it the skill of only people over here? That's the reason Mumbai Vada Pav is not protected under GI. Got it? Only three but I'll tell you one thing. Honestly, now the mainstream media loves the GI a lot. They say Mahabaleshwar strawberry को patent मिला. हम लोग भी यही सुनते हैं. हम लोग टाइम्स में भी यही पढ़ते हैं. Right? No, these are not patent. These are GI. Why do we have GI? These are community rights basically. These are community rights. When I say community, it is not about the caste, religion, but these are the rights given to the local manufacturers, and these can be filed only by either a university or a association of manufacturers. Okay? Now that's how the community. Why do we have GI then? So हम लोग patent are private rights, मेरा research है, मेरे को दे दो rights. Same for industrial design, fashion design में कुछ अलग किया, मुझे दे दो rights. Why do we have GI? Why do we have GI as a right? Safety of that community. Why is it required, sir? Chappal wala. Okay. I'll give you an analogy. Like, you know, last summer my wife told me to, like, you know, get some fruits for the first time. Like, you know, it was an opportunity for me to showcase my skill. Actually, like, you know, कि मैं भी घर पे कुछ काम कर सकता हूँ, honestly. I went out to, and she had told me, instructed me, like, you know, to get original Alfonso mangoes. I went to the fruit vendor. Regular fruit vendor. I went to him, I told him, give me some Alfonso mangoes. वो as usual, first, नहीं second, नहीं third दे देता है वो, right? वो इधर देखेगा, and third दे देगा. You feel like, वो original अच्छा वाला ढूंढ रहा है. But he doesn't do, it's a marketing tactic actually, or selling tactic. वो third वाला ही दे देता है, second या third वाला, right? उसने दे दिया. I was very proud of myself. कुछ तो लेके आया, कुछ तो घर पे काम किया. आज शाबाशी मिलेगी. That's how it works, right, sir? Absolutely. Now, I went home. My wife told me, तुम्हाला फसवलं. You are cheated. I'm also a lawyer. I told her, मला 18 वर्षापूर्वीच फसवलं. Now, how did my wife, oh, that was on a lighter note, huh? How did my wife, how could she recognize that I have been cheated? These are not original Alfonso mangoes. She's a daughter of a farmer. She has actually been involved into the farming and वो cultivation से लेके वो जब उसको सब वो समझ में आता है basically. I am a layman, मेरे को समझ में नहीं आता. Now, there are two set of people who got cheated in this transaction, and I'm not speaking about my marriage. Exactly. One I am as a consumer, I have been cheated. And the second one is the original producer of Alfonso mangoes or strawberry, जो महाबलेश्वर strawberry के नाम पे वो बेच रहा है. So community rights are the rights, geographical indications are the rights given to the entire community to protect their identities or skill set. So we call geotagging of the products. When we actually globally do that, so original authentic products, so there is a GI tag number as well that goes basically on the containers or the boxes basically. That's the significance of geographical indication. Design dekha, patent dekha, GI dekha. The fourth one was copyright. Now, so copyright has applicability everywhere, right? We discussed about the YouTube channel. Which industries are dependent on copyright? Film, the entire Bollywood, Mollywood, Tollywood, everything. The entire software industry, website, jitni sari websites hai, content creation industry, jo influencers hai, an interesting story I think Janvi ne bataya tha about Yash Raj films. I'll tell you another interesting story about, again, the Yash Raj films as such. Delhi mein शादियां बड़ी धूमधाम से होती है. Now, the one fine day, सारे resorts को एक legal notice आया. Yash Raj Films said, हमारा music मत use करो शादियों में. Why is it so? Copyright? There is a copyright with Yash Raj Films. Okay, मेरी शादी में भी DDLJ का गाना लगा था. Right? हमारी शादी तो हमें क्यों नहीं आया notice? Do they treat us differently? Exactly. Now what happens when a resort owner or a wedding planner, so that's where the commercialization angle comes. Okay. So if you are commercializing, you are taking money out for it, then that's where they are enforcing. Long back, 20 years back probably, when you go to theater, you would see local theaters में camcorder लेके recording होता था. Dare you do that in anywhere in India, globally now? It's not allowed. आप अपने phone के through भी नहीं कर सकते. Actually, that's how the industry has come today, for the enforcement of their. पहले क्या होता था? Movie release से पहले आपको torrent website पे मिलता था. अभी मिलता है क्या? Reason being, now they have used the technology at its best to enforce their rights, basically. Now what happens, again, I'll tell you the same, theory as such. 15-20 years back, we had CD shops, local CD shops होते थे. अच्छा, how many of, अच्छा, so torrent website से movie download करके देखा है, free में, after some time. Everyone has done that. You know that's an infringement. You are actually using third-party rights. अच्छा, आपको जेल में क्यों नहीं डालते फिर? Actually, it's a criminal offense. Huh? I'll tell you honestly, it's still not allowed. It's still not allowed. But from a broader perspective, if they see Yash Raj Films has to enforce their rights, what they would do is they would try to enforce जहाँ पे उनका business harm हो रहा है. Business कब harm हो रहा है? जब वो CD shop वाला download करके सीडी राइट करके सेल कर रहा है. Pardon? That's a good idea, sir. Now, honestly speaking, that like nowadays that's the reason most. अभी क्या कर रहे हैं? Original production house ही उसको YouTube पे डालता है after some time. Or maybe during my time, 20, 25, 30 years back, कोई movie टेलीविजन चैनल पे आने में 3, 4, 10 साल लगते थे. अभी 45 डेज में मूवी टीवी पे ही आ जाती है. उनको पता है उसका वैल्यू तो खत्म हो चुका है. और ये पायरेट्स आर गोइंग किल देयर business anyway. That's the reason. What would you prefer, watching the movie on Google Meet, which is a pirated version, or at your home, which is through the OTT platform, or on a TV? We are now bothered about the quality as well, right? We are willing to pay for that, right? So the copyright is for newspaper. How is it connected to us? मुझे एक बात बताइएगा. So copyright का एक interesting thing ये है कि the moment you create it, you own it. The moment you create it, you don't need to register it basically. Okay, but then copyright हम registration क्यों करते हैं फिर? Many times we do copyright registration. I'll tell you an interest. All faculty members can correlate to this. Many of you may be having books written on your name, right? Just raise your hands. Just though some books you have written. The fact is that, the harsh fact is that the publisher earns more money than an author. Publishers earn more money than an author. Reason being that आपने आपके copyright, आपको तो book एक right, I have these many books in my name करके आपके KRA के लिए you are writing it, but then they are the one who are commercializing it and getting money out of it. आप आपके copyright दे देते हो basically. When you accept those terms and conditions while writing a book, when you accept those conditions while when your manuscript is accepted in a research journal, you are actually giving all the copyrights to the publishers. That's the reason the research journals and the publishers earn more than authors actually. So copyright has applicability in this. What happened to that content which you created during COVID time? COVID time में online classes ली थी, सब कुछ online आपने record किया, you put it on certain media as well. कुछ लोगों ने YouTube channel पे, they put it on YouTube channel. What happened to that content? The copyright is with you. Why are you not filing for a copyright registration? Because वो intellectual creativity property नहीं बन रहा है. And that's the reason, अभी क्या हो रहा है पता होता हूँ मैं. When we think of intellectual property rights, because of patent agents or because of NIPM, what Sagar sir mentioned in the morning, a lot of awareness about IPR. Intellectual creativity को legal rights तो मिल रहे हैं, intellectual rights तो मिल रहे हैं, but it's not a property. It's not a property. There is no commercial value. I'm saying, no, you file it. You file it actually. For any kind of IP, try to understand this. IP never gets commercialized. Why I'm saying so? Intellectual IPR, the rights do not get commercialized. What do I mean by that? Firstly, try to understand this. Ye product, it has a value in the market. It has a value in the market, then only it can be sold. आपका IP, आपका content, आपका research project, उसका market में value है, then only it would be sold. What is happening out is, अगर इसका सिर्फ IP है, then it won't be sold. I see lot of people, मेरा patent मिल गया, now I'm looking for commercialization of the patent. No, it doesn't work that way. आपके product, can it be sold in the market? If the answer is yes, then you don't need to look out for a partner to sell it. आपके product का value है क्या commercialization का? If the product has a value, then comes into picture, अगर आपके product को value है, आपने research paper publish किया है, no one needs you then. You don't have a legal right for that. No one needs you. You don't have a legal right for that. I have this wonderful slide. Yeah. Exactly. Now what happens is, हमारे research project का value अगर है, then only someone would come to you. What happens as a research paper once you are publishing, that point of time, you don't have a, look at this, you don't have a legal right. You don't have a legal right. You have right only as an author. मतलब अगर वो प्रोडक्ट कमर्शियलाइज होता है तो आपके पास राइट्स कुछ भी नहीं है. What is happening with IP, maybe because of agents like me, हम लोग रिसर्च का पेटेंट तो ले रहे हैं, but then the research doesn't have market value. पेटेंट तभी बिकेगा. Okay, simple logical question. I have this, let's say a pen. Can I have the pen again? इसका वैल्यू, मार्केट वैल्यू 10 रुपया है. Would you pay 20 just because it is patent protected? Simple. इसका वैल्यू है नहीं. Just because it is patent protected, are you gonna purchase the product? Is it going to be commercialized? No. आपकी need है. आपकी need है. Then only you would buy it. What is the value for this? Then only you would actually buy it. When we are selecting a research project, at that point of time, are we thinking of a need of that subject or a project or a research hypothesis basically? What is the value for that basically? Is it really required? Okay. हमारा research, हमारा IP कैसे हो रहा है? So these are the market terms we call pull and push. We are trying to, मेरे पास ये product है, मुझे ये push करना है कि आप ये ले लो. How does IP work? मैंने जो create किया, is there a need in the market? If there is a need, then probably there is a strong pull from the market. It can be commercialized. That's how the concept of IP actually works. Intellectual property and intellectual property rights. Commercialization क्यों नहीं हो रहा? Because हमारे project का value है ही नहीं, sir. I have this confidence. हमने 93 applications prosecute किए. We just have 2 applications refused. आप मुझे अपना thesis दे दो. I know as an expert, how can you get a patent out of it? What is the value? That so intellectual क्या उसमें है, उसमें क्या creative है वो मैं identify करके उसके rights दे दूंगा. But वो property है कि नहीं, that I have no role to play in that. And that's the reason we have so many patents filed, getting registered, but not getting commercialized. Okay, and that also gives us a wonderful, perspective here in, firstly, patent is not mandatory. Patent is not mandatory. What is mandatory for, I'll tell you, for 3 sectors. For the pharmaceuticals, FDA registration is mandatory. For the agrochemicals, the registration with the regulatory agencies mandatory. 6G, 7G का आपको patent मिल सकता है, but Telecom Regulatory Authority of India should approve your product first, right? So patent is not mandatory. Why are we filing patent then? Why are these companies filing patent? Because they know that अगर मैं patent file नहीं करूँगा, they have that capability to commercialize. They know there is a market value for that. अगर मैं पेटेंट नहीं फाइल करूंगा तो next day someone would copy it. Next day someone would copy it. So I don't know whether it was covered in the first session, Janvi. IPR are negative rights. Yes. Negative rights means it excludes everyone else. I can tell you a wonderful example. All of you have seen 3 Idiots? Yes, the character played by Funsuk Wangdu by Amir Khan, right? He's a scientist. He's not interested to commercialize. Now, it is shown in the movie that Chatur Ramlingam comes to meet him. And now what we feel, हमारे पास patent मिल गया ना, then वी आर फुनसुक वैंगडो, हमें भी कोई $1 million दे देगा. Practically, it doesn't work that way. So it is Chatur Ramlingam who wants to commercialize those patents. And that's the reason he is coming for license. Remember this, जो research फुनसुक वैंगडो ने किया है, it is commercializable. Many of you are from Maharashtra, Marathi कळतं बऱ्यापैकी तुम्हाला. There was this one wonderful movie called De Dhakka. There was this one character played by Makaranda Naspure who invents a part which enhances the fuel efficiency. At the end of the movie, it is shown that त्याचा जो dashing मेवना आहे तो विकतो त्या पार्टला, right? Now that point of time, there is at the end of the movie for a minute it is shown. So Makaranda Naspure is like, he goes back to his house. He feels he has lost the technology basically. Now what happens? His friend comes and he tells him one thing. अरे मी तुझ्या नावाचं एक patent file केलंय. Means what? And no one else can use it. ती company आता काहीही करू शकत नाही. IP, all types of IP work on this principle. But coming back to actual topic about the global scenario. We think of Prada and Kolhapuri Chappal. We think of local products going globally, but try to understand this. All IP rights are jurisdictional rights. Means आपको अगर इंडिया में rights मिले हैं, तो आप सिर्फ इंडिया में enforce कर सकते हो. Is it clear? तो Indian Patent Office, the gentleman who was there in the morning, he is from Indian Patent Office. He can grant the patent, or his office grants the patent only in India. Okay? This is a general process how IP works. IP registration basically works, wherein at any point of time, before disclosing it to an agent or a scientist, anyone for your collaboration, you sign a CD or non-disclosure agreement. Then we evaluate the feasibility की at least हमें ये पता है कि now GI is different from copyright, design, trademark and patent. Now don't ever say that sir मेरे patent का design का copyright करो. Come up with a very concrete term. Sir मेरे को design चाहिए, industrial design. Don't ever say design patent. Clear? We check that feasibility internally. We draft or we create those documents which are required. We file it with IP office. The journey of a patent, of course along with the fees, the journey of any type of IP from filing till grant or registration is called as IPR prosecution. Intellectual property rights prosecution. That's a legal term basically. Filing से लेके grant तक का और filing से लेके registration तक का जो journey है, that is IP prosecution. IP gets granted or registered. Is it over now? Most of the people feel it is over. I'll tell you how IP works. And also what is important to understand from IP perspective is that आप अगर खुद IPR नहीं ले सकते, that's absolutely fine. But make sure, see, we have given gadgets to our 4 or 5 year old kids as well. It is our duty to let them know that they have to actually, make sure they are not using third-party IPs. They have to respect third-party IPs. Kisi aur ka, intellectual property rights. I have some wonderful examples wherein people tried to share the data from one company to other, and then they actually, of course, there were criminal cases as well filed against them. Or sharing the secrets, the trade secret, what Janvi mentioned in the morning actually, or any. So it is very significant. हम अगर नहीं create कर सकते, we have to respect third-party IP as such. That we have to, understand it. What happens? मेरा गांव में ज़मीन है. Someone does encroachment. What do I do then? Pardon? No, I'm generally, I understand land is not intellectual property. I'm asking you about a tangible property actually. What would you do? So would you sue the person, or would you wait for police to go and take action? You have to initiate it. Think of the same for IPR. कोई और अगर आपका IP use कर रहा है, it is your duty. Registration is different. IP registration मैं आपको patent लाके दूंगा. I'm an agent, I do that. I'll do it for patent, trademark, copyright, design, anything I get it for you. When someone else uses it, it is your duty to ensure that you stop them. You have to go legally. You have to go to court basically to stop them. And that's where the legal aspect comes into play. Absolutely, yes. And therein agents are not allowed. Only the litigating lawyers in the high court or district court, they would be the one who would be doing it. Of course, you can give power of attorney in that case. Right, now, that's what we call as enforcement of IP. वहाँ पे जो term enroachment है, in IPR the term we use is infringement. And broadly, infringement and enroachment, like, so therein we use the terminology that is being used here in is enforcing our own rights basically. Making sure that no one else copies my rights. Right now, we have discussed this patentability requirement. So we have these novelty, obviousness, and industrial applicability as the requirement. But Section 20, Article 27 of TRIPS allows every country to have its own legislation or certain exclusions. Means क्या है? Now we are thinking from local to global. हमें a company like, let's say, Microsoft or a Pfizer or a BASF or a Merck, they sell products cutting across the jurisdiction. 200 countries में बेच रहा है, right? Now every country, as I said, IP rights are jurisdictional. That means आपके पास अगर एक technology है, एक product है, आपको 200 countries में patent file करना पड़ेगा. If you are selling in 200 countries. That's how do we decide these markets then? Do companies really file patents in 200 countries? कभी-कभी ऐसे होगा कि मेरा वो patent filing का budget would be more than the sales revenue, annual revenue basically, right? Who does that then? Those companies. So how do we select these markets? We select those markets जहाँ पे भी मुझे बेचना है. Don't get confused. There is nothing called a global patent. There is no concept called global patent. It is jurisdictional. एक country में जब आपके पास right है, तो उसी country में आप enforce कर सकते हो. India का patent सिर्फ India तक ही restricted है. But then, what happens? मेरा research तो same है. Every country has different legislation. तो same invention को आपको 200 पेटेंट 200 कंट्रीज में मिल सकते हैं. सेम इन्वेंशन को 200 पेटेंट्स इन 200 एवरी कंट्री में एक. गिव मी दैट मनी, आई विल गेट यू दैट. सो इन यूएस वी हैव 10 to 15,000 $US. That's the expenses that you would incur basically, which turns out around, I would say, 9 to 10 lakh rupees for patent getting granted basically. In India, like, there was a discussion, maybe 52,000 to 1 lakh from filing to grant. The same applies for design, the same applies for trademark, the same applies for copyright, the same applies for GI as well. Now the key thing herein is, when Prada uses the Kolhapuri chappal, are we actually in a position to enforce? It is possible only when in those countries जहाँ पे वो manufacture कर रहा है आपके पास rights हैं. Do you have the rights? What do we do now? Culture or tradition जो हम, especially in case of GI, the global, the communities or the countries are filing GIs in every country. Here in India, we have GI for French wine as well, France is very much like into it, and they protect the GI, so no one can actually make that right here. So now this is from local to global. You have to get it registered in every country, and every country has different legislations. Article 27 actually allows you to make changes to your laws, internal laws. How is it being done in India? I'll tell you, we have this wonderful section called Section 3D in pharmaceuticals as such. India ने क्या किया है? ये सारी चीजें allowed नहीं है for patent. For those of you who are from software, softwares are not allowed to be patented in India. Those of you who are from pharmacology, second medical use are not allowed to be patented in India. Similarly, look at this last section 3P, TK, traditional knowledge, not allowed to be patented in India as such. Now there are different things, like for example, as I said in pharmacology, second medical use are not allowed, but in a country like US, these are patentable. Also, as an agent, I am allowed to file IP only in India. So if you want to file it in US, Europe, globally if you want to file, that point of time, you need a local agent or attorney in that country, then that's where the charges would be multiplying that way as such. So all these are protection. Like for example, in India, atomic energy related inventions are also not to be protected, or they are not allowed to be patented basically. This is because we have internal laws. Globally they may be allowed. So you may get a patent in some other country. But in India, no, you are absolutely not allowed to get it. This is how the local, okay, let's think of brands now, global brands, right? The Adidas, the Nike, or सुबह जो भी discussion हुए थे, KFC, Pizza Hut and all. These are global brands. In every country they are filing trademark. Are you getting it? In every country they are filing trademark. In every country they are filing for the copyright. आप जब YouTube चैनल पे आपका वीडियो अपलोड करते हो, that point of time, global check is being done. Does it actually copy any content from third party? If yes, हो सकता है मैक्सिकन कोई क्रिएटर हो जिसका म्यूजिक आप यूज कर रहे हो अपने YouTube वीडियो में, still there would be a copyright notice to you. Right? So this is how the local to global things work. We say, for example, the same thing, the Jewelry Design Institute develops some jewelry. The rights are jurisdictional. हमने इंडिया में डिजाइन फाइल किया, still someone can use it in US, Canada, Europe, Australia. But if you want to stop there, you file design there as well. Now how to match, हम लोग, when we think of commercialization, even हम Indian patent का costing नहीं bear कर पाते, how would we be actually be in a position to bear all this costing which is related to the global filings as such, right? So that's the context, and I'll tell you the laws are same or similar. There are minute changes. Like India doesn't allow certain patentability or certain things actually. More or less, so the way you have this passport, right? You have passport and we have these visa proceedings, आपको visa मिला, globally you can go, so Australian visa मिला, you can go to Australia. The procedures are same, but minute differences. Similarly, आपने एक country में patent file किया, उसके बाद you can actually go to anywhere in the world with the minor differences. However, there is a restriction to this. Till how long? Is it possible to file a patent in 200 countries on day one itself? No, it's not absolutely possible. So we have two mechanisms through which we can do it globally. The first one, what we call as a convention application. तो आपको, जैसे for example, if you want to file it within 2 or 3 countries, you go through convention application route. India में file करो, within 1 year Australia में file किया. So you have a patent for the same invention now in India and Australia. You have the invention for the same invention. You have the right for the same invention in India and UK, India and Brazil, anywhere within 1 year. This is one way to file. जब number of countries less है, we use this convention treaty. The other is 3-stage process wherein we file in India and there is a centralized process called PCT, Patent Cooperation Treaty, or WO worldwide, जो बोलते हैं WO application. Herein, PCT doesn't get granted. It is just, आपने अगर PCT file किया, it is presumed that you have filed in 200 countries. And you go in any country wherever you want within 2.5 years time, 30 or 31 months time. Why are we getting these timelines? We are getting these timelines. आपके पास 30 months है to decide whether आपका product US में बिकेगा, कोई लेगा, Canada में बिकेगा, ऑस्ट्रेलिया में बिकेगा, मैक्सिको में बिकेगा, वो डिसाइड करने के लिए हमारे पास 2.5 years है. That's how the second system or the PCT system actually works as such. I think I have already covered this. This is the last slide I have about the different treaties. As I said, through TRIPS or WTO, we had these discussions long back in 1995 or 1996 when India adopted TRIPS basically. That point of time, we had all these treaties and we have signed these treaties. Our laws are in compliance. So for example, just like the passport, we have the patent system when you can actually file in one country and go to anywhere in the world within 1 year to file the same invention, depending on your needs basically. हम लोग हर country का visa नहीं लेते, right? जहाँ जाना है उसी का visa लेते हैं. Similarly, जिस country में आपको बेचना है, जिस country में आपके invention को value है, सिर्फ वहाँ पे आप patent file करो. What happens is, firstly, I think now everyone knows that there is nothing called design patent. It's an industrial design. People call me, सर आप वो UK patent करवाते हो क्या? सर आप वो Australian, African, German patent करवाते हो क्या? Let me tell you, most of the times they are designs. In US they call it design patent. Why is it required? I'll tell you, it is very significant to understand. Same product का patent और design हो सकता है. Design has a value not just because it's of its aesthetic look. At times, a particular product works only when it is in a certain shape. Am I correct? In that case, the functionality is connected to the shape. Therein design has a lot of value. It is just not about the appearance. It is just not about external appearance. Agar that appearance has something to do with its functionality, then design has a value which is equal to patent. Right? That's how we can actually protect it. I'm finishing my slides on time just based on one. I actually included this slide in the morning, like, you know, when Mr. Sagar was mentioning about patent agent, he mentioned about, right? Yes? Just to let you know, we also conduct the classes. Of course, this is something which is like, you know, for those of you who are students actually. Patent agent is a great career as such. We are rather the best class in India for the patent agent examination. The exam is scheduled for 11th of January. The registrations are open. If you are a science graduate, you can appear for the exam. There was a question asked in the morning, why are we learning this? हमारे पास patent agent है, पैसा दे दो, वो आपको patent दे देगा, right? That's what the question. Why are we learning this? Actually, I'll tell you a different perspective, my perspective. I didn't want to interfere in the first session. I have a better answer actually. When I deal with the scientists, half of the time, as I said, the first thing they say, मेरे design का patent का copyright करवाओ. एटलीस्ट आज के बाद ये 20 लोग ये नहीं बोलेंगे. First thing. Second thing, when you understand the process, when you understand how the different types of IP, how it goes, what is the life cycle, that's what you are going to learn in next 5 days. It would become easier for you to deal with the agent. सुबह जैसे सर ने बोला, he is not recommending to go to a patent agent. In fact, I'll tell you, I also don't recommend you to go to an agent unless and until you have that time, confidence. When I say confidence, in terms of what, I'll tell you. Patent, unlike a research paper, is a techno-legal document. Research paper is a completely technical document. The legal aspect of it, that's what we learn in the patent agent exam preparation actually. And just for your information, I can name those faculties. I had last year and before that, I had, I would say 4 to 5 faculty members from mechanical engineering, from electronics, from computer sciences, from pharmacy, faculty members, dean, assistant professor, associate professors, who cracked the patent agent exam actually. We run the classes, as I said, we are the best class in India. Successively 2 years, we had All India rank 1 from our classes. We are, of course, if anyone is interested, we'll be happy to help with that also. Now, again, ending my session on a simple note that if you become a patent agent, you can only file the patents in India, because these are jurisdictional rights. The global filings, if you want to go outside India, you need a local agent for that as well. Right, I'm done with my session, and I'll be happy to answer if there are any specific questions with respect to my session as well as Janvi's session, or generally with respect to intellectual property rights as such. Thank you, everyone. Yes, please.
So just curious to know why softwares are not patentable in India.
Wow. Okay. That's a policy call taken by government that, okay, we can't have softwares under patent. Okay. Honestly speaking, this is also to protect the local industries. IP creates monopolies. Intellectual property rights create monopolies. Similarly, we don't have patent for drugs when they are over, like there is the term called evergreening basically. Naya salt banate ho, naya polymorph banate ho. So that's a policy decision taken. But then softwares are protected under copyright. Not under patent, but copyright, yes. Okay? Yes, ma'am, please. Yep. Yeah. Okay, now.
Sir, this is regarding a product like basmati rice. It was a controversy, and I honestly didn't follow it up much. But the thing is, like Pakistan had tried to patent for it, and I don't know whether they got it or not, but India has got it. Punjab is given the patent for basmati rice, if I'm not mistaken. So my question
you are
is,
not mistaken. Yes, you are
can
not
one product be patented in 2 different countries?
That's what we tried to discuss firstly. But let me correct you first. It's not patent, it's GI. Geographical indication. Now, the same products can get GI. The way I said, Devgad Hapus and Kokon Hapus has different tests. Both of them can be protected under GI. Same thing with, I would say, the Maliyabadi Dashariam. There are 25 different varieties. In fact, there was a wonderful map, I have it actually, jahan pe different uniqueness of mangoes, taste, in terms of taste, and how it is connected to local soil and climate. Everyone can get that. That would have a different, unique identity. So I think as far as this, the example that you mentioned, Basmati, unfortunately in that case, we know, honestly speaking, long back, India, Pakistan same ही तो था. And now we have created those lines. Punjab, Amritsar से 50 किलोमीटर पे तो लाहौर है. मिट्टी same है. Basmati quality would be the same, am I correct? Now both of us are fighting. Both of them are fighting. There was an interesting case of Roshagulla, Odisha versus West Bengal. Who owns it? Right? Border hai, baju mein hai. Like, you know, it's like Mukesh bhai and Anil bhai are fighting for Reliance actually. Right? Now, so this is like, you know, broadly about GI, that's how it works. Now, can the same patent be filed in multiple countries? I think I have covered in the entire session. Yes, absolutely, it can be done. Rather, one invention in all countries, those who are running after numbers, na just एक invention करो, 10 crore का budget रखो. Absolutely, I am not going to give you.
Suppose sir, we have filed patent in 3 countries and suppose 4 countries using my or copying my product.
You can't stop them. No, you can't. जिस country में these, that's why they are jurisdictional rights. जिस country में file किया है वहीं पे rights है. I'll tell you a simple example which would give you clarity. It's a analogy, simple analogy. हम लोग जब like when I was in school बस से जाते थे school के लिए, जैसे ही बस आता था, the very first thing we used to do, like, you know, we used to keep a handkerchief there. Right? कभी कभी भाई साथ में तो 2 जगह block कर दिया. Now only those 2 seats are mine for that journey. Am I correct? जितने countries में file करोगे patent उतने countries में rights है. अब आपके पास 100 countries में file करने लायक budget है, but why are you filing in 100 countries? But are you gonna sell it? Are you gonna sell the product there? See, when there is a commercial value for, let's think of commercial value of a product like, let's say you come up with a wonderful drug which is being used for COVID-19. There is a commercial value in every country. File the patent. You would get any investor for that sake very easily. Okay. Just for your information, there was a lot of mention about Kapila in the morning. Beyond that, now NEP allows you to have your own startups. If you have your own startup, and if you have MSME authorization certificate, Government of India reimburses, this is a reimbursement, reimburses 1 lakh for Indian patent and 5 lakhs for any foreign patent, irrespective of number. आप अगर 100 countries में कर रहे हो, तो 5 lakh into 100, 5 CR you would get in your account after the patent gets granted. That means आपको expenses पहले करना है, and then you get the money. That is when you have, there is a, आपका जैसे आधार कार्ड है, in the startups and MSMEs we have this concept called as Udyog Aadhaar, MSME authorization certificate. If you have that, you are eligible for that. Okay? Any other questions?
Here.
Yes, sir, please.
Is there something called as open patent?
Open?
Patent?
Okay, there is a different term. I'm just missing on that term actually, like, you know, open innovation or, okay, they also call it patent pool basically. The term herein is that, like, for example, pharma industry does that, software industry does that actually, like, you know. There are a lot of inventions I am coming up with. एक molecule market में जाने के लिए thousands are rejected. Or, like, you know, in the software industry as well, they are coming up with a lot of codes, lot of softwares basically, which are useless for them. But when they are coming up with an end product basically, right? What they do is, whatever is rest of the things, they make it open for everyone, actually. They say you work on these, agar isko commercial, they have the IP with them. They have the IP with them. You use it, basically. When you use it, if you are in a position to generate money, give us some royalty. Otherwise, you are free to use. So, like, you know, it is also, pardon?
Just like a Creative Commons.
Creative Commons license absolutely falls under the similar category for copyright thing actually. Yeah. So in patents, we call it patent pools actually. Atom bomb ka patent chahiye. Oh, atomic energy, under section 4, it's not allowed. Any other questions? I'll end up with one question. How many patents did Funsuk Wangdu have in the movie Three Idiots? Okay, let me ask you. How many patents did Ranchorda Shamalda Chanchad had in the movie Three Idiots? 400? More than 300? Yeah, exactly. Ranchorda Shamalda Chanchad had 0 patents. And Funsuk Wangdu had 400 plus patent. हमारा सारा ध्यान आमिर खान और hello ma'am, Kareena Kapoor पे ही था. That's the reason we missed out on the patent part in the, I would say, the movie Three Idiots. Thank you so much. It was pleasure to be here as such. I'll also be here for some more sessions as the university has allowed me, and I think we also have. You have some question? No. Feedback. Acha. Okay, and I'm really honored to be here for, I think, 4th or 5th time at this very same venue as such. I've been fortunate to work with PVP for IP filings, the design filings, and I'm also fortunate to work with Pratima ma'am since long actually, and I would say I had this privilege to be here today. Along with her, she would be the one who would be having a session after me. Welcome to the program, ma'am, I would say, and thank you so much, everyone.
New form of known substance which does not result in the enhancement of known efficacy of the substance, or the mere discovery of any new property or new use of a known substance or known process, machine, or apparatus unless such known process result in a new product or employs at least one new reactant. And then there are many more examples, but any invention which in effect is the traditional knowledge, or which is an aggregation or duplication of known properties of traditionally known component. So that is also, like, if the knowledge is already there existing in the traditional books or granthas, then sometimes it is not patented. And also inventions relating to atomic energy also are not considered patentable. There are many more examples: plant, animals in whole or any part thereof, other than microorganisms, including seeds, varieties, and species, and essentially biological process for production and propagation of plant, animals, then mathematical and business method, or a computer program also is not patented. Then presentation of information, topography, and literary, dramatic, musical, artistic work, that can be copyrighted but not patented. So persons entitled to apply for patent, persons claiming to be the true and first inventor of the invention, any person being the assignee of the true and first inventor of the invention, by the legal representative of any deceased person who immediately before death was entitled to make such application. So any of these can be, they are entitled to apply for the patent. Patents protect invention. So you need a patent if you have invented a product, you want to market yourself or sell to a manufacturer. So any idea from your innovative idea, if you have invented a product, then you should patent it before making it commercialized. You believe someone else could sell the product by copying your invention. So if you feel that somebody will copy your idea, then you should protect it by filing a patent. So patent application must include in-depth description of invention, drawing of invention, completed declaration for patent application, notarized statement from inventor, filing fee to patent and trademark office. All these are given in the guidelines. I have just highlighted few. So first you file a disclosure document So that is the date of conception of idea. Suppose you have thought, you have something in your mind and you think it is novel, you can file a disclosure document and you get 2 years grace period. So within that period, you should file the patent. Or suppose you are carrying out your research and then after few steps you have come to know that your product or whatever your idea is something which is novel and which you think is patentable, then before carrying out further studies and confirming it, you can file a provisional patent application. So that is you are booking or blocking the date. So protect your ideas while taking to manufacturers, potential funders, and then you can use the term patent pending on the invention. So provisional patent means it is provisional and then you can file within a period of 1 year. You must file the application. Otherwise the date will go. So directly you can go for provisional patent filing, or if you have everything ready, you can go directly for the filing the complete specifications. So file non-provisional patent application, file complete description with the Patent and Trademark Office. So patent applied for, which gives you 2 years protection for further processing. So here you are filing complete specifications. So usually what we do, file as soon as you feel that your invention is patentable, file a provisional patent, and within 1 year you carry out complete study related to that patent and then file complete specifications. So these are the what you say steps involved in the patent. First you have the idea. Then once you have the idea, you go and file the, so idea generation, then filing of application, after many steps, grant of patent. Then once the patent is granted, you have the rights, and then monetizing the patents, you can convert it into, you can commercialize and convert into for generation of funds and using profits on R&D. So patent infringement is another important aspect. So it is, infringement means use by a person other than the patentee or his assignee or licensee. If the patent is used, then it is infringement of the patent. So civil remedy is filing of a suit in a court of a competent jurisdiction. There are many slides on patent infringement. I think I can skip those. But patent infringement is another important aspect, and you can file the complaint in a district court and then high court and then so on. So there are provisions for that. This I would like to show. He is the youngest patent holder on wheelchair from Jaipur. He Hridayeshwar Singh Bhatti. He has got the game's design patent. He has invented a game of 6-player circular chess. So he's the youngest person. So coming to the trademarks, you can see a bottle of Coca-Cola. The name in the style in which Coca-Cola is written, that is a trademark. Then shape of the bottle. Then you can see the logo type. That is of? What is the logo of? The first one. Nike. Yes, so that is again a trademark. Then symbol is of? Yes. And even the slogan associated with, so I am loving it. That is also a slogan which can be which is a trademark. And color orange. That is of? So trademark, the act is in 1999. It defines trademark capable of being represented graphically, which is capable of distinguishing the goods or services of one person from those of others, and may include shape of goods, their packaging, and combination of colors. So trademark includes device, brand, heading, label, ticket, name, signature, word, letter, numeral, shape of goods, packaging, combination of colors, and any combination of thereof. All these come under trademark. Trademark and brand. Brand refers to the name, term, sign, symbol, design, or a combination of them intended to identify the goods or services of one seller or group of sellers and to differentiate them from those competitors. That is the way McDonald's for restaurants, the way it is written, or cycle brand agarbattis. So these are brands. Then brand name is the part of the brand which can be vocalized. Brand mark is the part of the brand which can be recognized but is not utterable, such as symbol, design, distinctive coloring or lettering. Then device comes under this, which refers to pictorial representations, that is animals, birds, landscape, buildings, etc. And in trademark, letters are also there. Letter as a mark is the identity created out of the letter forms and has its inbuilt strength of distinctiveness and individuality. So IBM, GM, and so on. So these are various types of trademarks. Again, various terms are used to explain the trademarks, or so numerals can be registered as trademark upon evidence. For example, 555, 501, these are trademarks of cigarette, na? Then symbols may take the shape of brand or logos. So, yes. A logo is a visual depiction of manufacturer or company and gives an identity to it. So BMW, Maruti, Benz. So these names are associated with the particular company. The label and ticket mean a composite mark containing various features including devices, words usually painted on paper and attached to the goods themselves. The name is the word signifying a name, surname, or personal name, or an abbreviation thereof. This can also be a trademark. Color or a combination of colors can be considered as trademark. For example, color combinations used in drug capsules. Then sound. Sound or sequence of sound can be registered as a trademark. For example, roar of lion sound has been registered by MGM Pictures. The Tarzan yell has been registered as Edgar Rice Burroughs. Then smell can also be registered as a trademark. So smell, reminiscence of roses applied to tires was registered for Sumitomo tires, smell of fresh cut grass for the tennis ball, etc. Containers fall within the definition of trademark also. Then collective marks, service, and certification of trademark. These also are three features of trademarks. So one example, wool mark, ISO 9001. This is a certification trademark. Trademark and service mark are used before registration. Once the trademark is registered, it is for that particular company or the organization. Registration of trademark is not a compulsory requirement of the law. The Controller General of Patents, Designs and Trademarks Act, appointed by central government, is the registrar of trademarks. A register of trademark shall be kept in offices registered trademarks details shall be entered into register. Once the trademark is accepted, allotted, should advertise it in prescribed manner. A trademark registration is for 10 years from the date of registration and can be renewed every 10 years consecutively. So failure to renew is removal of trademark from the register. So it can be for lifetime provided it is renewed after every 10 years. Such a nature as to deceive or cause confusion and so on. There are many marks prohibited under emblems and names, or marks consisting exclusively of the shape of goods which result from the nature of the goods themselves. For example, apple design from a package of apples, round shape for tennis balls, etc. These are some of the trademarks and service marks which are popular, and then trademark infringement is also common. A trademark that is likely to cause confusion with a trademark already existing in the marketplace, that is infringement. Counterfeiting is the deliberate copying of a mark, and dilution, the value of the mark is substantially reduced through competition or through the likelihood of confusion from another mark. So you can see Starbucks and Starbucks coffee. So there is a similarity, and that is infringement because it is very similar to Starbucks, the name, and the way it is written, and that is copying. Similarly, the pizza, Parkway pizza and even Apple, you can. A trade secret is not protected by the federal law. It can be protected through employment contracts and or maintaining tight security. So examples, recipes, ingredients, codes, manufacturing costs can be trade secrets. Then geographical indications is an indication originating from a definite geographical territory and used to identify agricultural, natural or manufactured goods. The manufactured goods should be produced or processed or prepared in that territory. It should have a special quality or reputation or other characteristics. So many examples are here. Gadwal, Pochampalli, Kanchipuram silk saris, Nirmal paintings, Beginapalli, Alfonso mangoes, Darjeeling tea, Kolhapuri chappal, Solapuri chadar, then Tirupati laddu, Nagpur orange, Bikaneri bhujia. All these are examples of geographical indications. Whenever we use this term, you know it is related to certain geographical part, origin. Then GIs, when registered, confers legal protection in India through the Geographical Indications of Goods Act of 1999. It prevents unauthorized use of registered GI, promotes the economic prosperity of the producer of goods. So this I think I will skip. Then layout designs of semiconductor ICs. It provides protection for semiconductor integrated circuit layout designs. India has now in place Semiconductor Integrated Circuit Layout Design Act 2000 to give protection to IC layout designs. And this layout design includes a layout of transistor and any other circuitry elements, and includes lead wires connecting such elements and expressed in any manner in a semiconductor IC. Okay, so any IC layout design cannot be registered if it is not original, commercially exploited anywhere in India or convention country, inherently non-distinctive, inherently not capable of being distinguishable from any other registered layout design. So there is a separate act for this. So reproducing, importing, selling, distributing the IC layout design for commercial purposes only constitutes infringement and specific. Then also plant variety, this is also specific to agriculture field. The International Union for the Protection of New Varieties of Plant, that is UPOV, was established in 1961 by the International Convention for Protection of New Varieties of Plants, which is known as UPOV Convention. And this provides and promotes the effective system of plant variety protection with the aim of encouraging the development of new varieties of plants for the benefit of society. So Indian BT brinjal. So this is a genetically modified varieties which are developed, and then they can be, protected under this act. So in order to obtain protection, a breeder must file an individual application with each authority entrusted with granting of breeder's right. A breeder's right is only granted when the variety is new, distinct, uniform, stable, and has a suitable denomination. So in the USA, there are two legal frameworks for protecting new plants on the owner of the copyright. It is a negative right, meaning thereby it is prohibitory in nature. It is a right to prevent others from copying or reproducing the work. It is not a single right, it is a bundle of rights in the same work. So example, in case of literary work, copyright consists of reproduction in the print media, the right of dramatic and cinematographic versions, the right of translation, adaptation, abridgment, and the right of public performance. It consists not merely of the right of reproduction, it also consists of right to works derived from the original work, rights like the right of public performance, the recording right, and the broadcasting right. Such related rights are called as neighboring right. The owner of the copyright has no monopoly in the subject matter. Others are not first in the field. Their work is nonetheless original. So there is no copyright in ideas. Copyright consists only in the material form to which the ideas are translated. There is no infringement of copyright to adopt ideas of another or to publish information derived from another, provided there is no copying of the language in which those ideas have or that information has been previously embodied. So it subsists in original literary, dramatic, musical, and artistic work, cinematographic films, and sound recordings. So literary work includes computer programs, tables, compilation including computer database. Dramatic work includes any piece of recitation, choreographic work, or entertainment in dumb show, the scene arrangement or acting form of which is fixed in writing or otherwise but does not include cinematographic film. Music work in copyright means a work consisting of music and includes any graphical notation of such work but does not include any works or actions intended to be sung, spoken, or performed with the music. Again, in painting, it means any such work possess artistic quality. A work of architecture means any building or structure having an artistic character or design or any model for such building or structure. Cinematographic film means any work of usual recording or any medium produced through a process from which a moving image may be produced by any means and includes a sound recording accompanying such visual recordings, and cinematograph shall be construed and including any work produced by any process analogous to cinematography, including video films. And even sound recording means recording of sound form, which such sounds may be reproduced regardless of method by which the sounds are produced. So each type of copyright they have given in detail. Here the word original does not mean the work must be expression of origin or inventive thought. It only means the work must not be copied from another work. In patent, it was mainly novel or originality. Here it is mainly copying. It should not be copied or it should not be originated from other author. So to qualify copyright in India, the work should satisfy the work is first published in India. Whether the work is first published outside India, the author at the date of publication must be a citizen of India. And in the case of unpublished work of the author, on the date of making the work, is a citizen of India and domiciled in India. So this again I will not go in detail. There are detailed information on economic rights and moral rights of copyright. The authorship of copyright, in case of literary and dramatic work, author of the work is the owner. In musical work, music composer is the owner. Artistic work, artist is the owner. Photographer, cinematograph, film, the film producer is the owner. Sound recording, the producer. Then literary, dramatic, musical or artistic work which is computer generated, the person who causes the work to be created. And the owner of the copyright normally is the owner of the work, will be the first owner subject to the following exceptions. So there are exceptions. Then infringement of copyright is also given in detail. So we discussed about various types of IP, that is intellectual property. Now coming to academic research, because my topic is role of IP in academic research. So very much in brief, I will tell you what is academic research, because we all do academic research. It is a systematic and in-depth investigation into specific topic, issue or question, usually carried out by students, research scholars or professionals in the universities and research institutions. So the main goal of academic research is to expand knowledge, test theories, solve problems or uncover new facts. And it is the backbone of steps. Define the problem or question, whichever is the discipline, these are the basic steps. Define the problem or question. So identify a topic that is interesting, significant and researchable. Formulate clear research question or hypothesis. Then second step, literature review. Explore existing studies, theories, findings, analyze gaps, contradictions and new angles in the current knowledge, and that is by doing exhaustive literature review by referring journals, books and materials available even on the website, various websites and search engines, databases. Then choose a research methodology. Decide between the qualitative methods and quantitative methods, or it can be a mixture of both. Then choose tools, data sources and techniques that fit into your purpose. Collect data or results. Gather information through surveys, lab experiments, observations, document analysis, and you have to make sure that ethical standards are followed. Once the data is collected, analysis of data is the next step. So interpretation of the research findings and test hypothesis. Then draw conclusions based on the analysis and interpretation. Report findings, explain the significance of your results, compare findings with previous research and suggest implications, and then write it all in a structured format, that is thesis, dissertation, paper, article, etc. And then review, revise and publish. Submit to peer-reviewed journals or academic conferences. Revise based on the feedback and seek publication to share your work. So these are in brief steps of academic research. Now, what is the role of intellectual property? It plays a key role in shaping how academic research is protected, shared, and commercialized. It is not just about legal rights, but it is about empowering innovations, collaboration, and impact. So first is protecting innovation and creativity. So IP safeguards novel inventions, software, literary work, and research data from unauthorized use. Researchers can secure patents, copyrights, or trade secrets to ensure their work is recognized and respected. Even design patents and trademarks ensure novel therapeutic strategies or analytical methods are not misappropriated. So while protecting, you have to ensure these things. Then it facilitates, protecting IP facilitates collaboration. So clear IP agreements help universities and researchers to collaborate with industry, government, and other institutions. And licensing and joint ownership agreements allow smoother technology transfer and share benefits. The technology transfer or share benefits are possible only after protecting your ideas or invention. Then enabling commercialization, IP rights allow academic institutions to license technologies, launch startups, and form industrial alliances. This turns research into real-world applications, fueling entrepreneurship and economic growth. Supporting academic freedom and recognition. IP ensures that researchers retain credit and control over their work, even when collaborating and or publishing. It balances openness with protection, allowing for both knowledge sharing and creator rights, especially in collaborative and interdisciplinary research. And this academic freedom is seen only in academic research. Nowhere else this freedom and recognition is seen. Enhancing funding and institutional reputation. So strong IP portfolios attract research grants, venture capital, and philanthropic institutional support. Institutions with robust IP management are seen as innovation leaders. So examples of all IITs, they have their own incubation centers which help them to protect their ideas, protect IPs, and then they are innovation leaders. Then navigating ethical and legal boundaries. So IP frameworks help manage confidentiality, data sharing, and ethical use of research outputs. They also address issues like indigenous knowledge, open source licensing, and global IP laws. So protecting your IP will, how will you protect IPs? By patent filing, by confidentiality agreements, where patent filing is not possible, at least confidentiality agreements are done, which are essential in industry collaborations, and student mentorship. Copyright registration for software publications and educational content, IP disclosure. Universities often require formal disclosure before commercialization. Then strategic considerations for researchers. So balance secrecy and dissemination, protect IP while enabling peer-reviewed publication and public benefit, open access versus IP protection. So here, understanding licensing item when publishing in open access journals, global IP laws. So be aware of jurisdictional differences, especially for international collaborations. So this slide shows the type of IP, IPR, and the covering obtained by each type of IPR. So patent gives protection towards inventions or innovative ideas. Whether you need to apply, yes, patent has to be applied and filed a patent, and maximum duration obtained is for 20 years. In case of copyright, it covers, gives protection for literary, musical, artistic work and software, but there is no need to apply. It is the maximum duration of protection is 70 years after the death of the owner, 70 years maximum. Then registered design, so it covers image, look and feel, and you need to apply for a design patent or registered design, and protection offered for maximum duration of 25 years. Then registered trademark, you can, it covers a name, logo, etc. And you need to apply for a trademark, and it should be registered. And the duration, the protection offered is for unlimited period. Confidential information, it covers unpublished secret information, and you need not apply for this, and unlimited protection is there. And in case of database rights, databases are protected, no need to apply, and protection offered for 15 years. So ownerships and rights, we have just seen in the previous slide. So collaborative research and research funded by external sponsors may have specific contacts that determine IP ownership and exploitation rights, often negotiated in advance. And there are university policies which have their own ownerships and right. Usually if you're filing a patent through university IPR cell, then university will have the ownership. And students generally own IP from their individual work unless special contacts, significant university involvement, or external third party funding dictate otherwise. And implications to researchers, determining IP ownership early helps. If you protect your IP, it helps to avoid disputes, enables publication and data sharing, and supports technology transfer to industry. Also, failure to manage correctly can result in legal liability, loss of commercialization opportunity, and restrictions on publication and data sharing. Few limitations may arise due to institutional policies, legal framework, and contact terms vary across jurisdictions and research context. Researchers should always consult their institution's IP office or legal advisors for specific guidance, because academic researchers do not have all this knowledge, so usually they take help of attorneys for filing a patent or other this. These are few references from where the information was collected. Thank you. I hope I have not bored the students who are sitting. Thank you. I would be happy to answer any questions if students are chit-chatting among themselves. I think for them it was very heavy topic.
Property of a university, and what it is then?
Sir, at present our university IPR cell is ready, and if you go through that IPR cell and if you file a patent, and if the university helps you in filing, like university's patent attorney, if you take help, then the ownership will be at the university, but your name as a inventor will be there, definitely. Or as an individual, you can also contact patent attorney, and you can also file, then the ownership will be with you. Collaborative means with industry. With industry or with other?
Other, not
see
industry.
that, then you have a, what you say, understanding, and whoever is putting the efforts. Like usually how we do, I can tell you our experience. We have filed a patent in collaboration. The work is done with collaboration with one industry. So as an inventor, like me and the industry person and the research student who has actually worked, 3 of us have filed the patent, and 1 person is the inventor. So later on, if it is commercialized, and then the benefits are shared between 3 of them.
Ma'am, consider the situation where we take industry project, and it is a research project, say for example, and student conduct the research. They submit the thesis to the university, but the company use it for the product. Now, neither students get royalty or nothing of that sort benefit that students get. Later, can student claim some kind of benefit or intellectual property right on that product?
So right in the beginning, it should be made clear with the collaborative industry, and the product is developed, the student's name should be there in the patent.
No, suppose that is not done earlier.
If
later
it is not patented, then you cannot...
no, it is not patented itself, but the product is there in the market. So can student claim any kind of royalty or something like that?
You can try claiming, but the industries are very smart. If they say that, no, we have modified the product, if you have any proof, like the thesis is there and the dates are there, if even the book where you write day-to-day your experimentation, if with the date and with the signature of the guide, if that is there, you can definitely consider that as a proof, and then you can go ahead. Yes, so first you should file a patent, and then you go for publication. That should be there. Even before thesis publication, you should file a provisional patent. You should take the date before publishing. That is there. So even